Good morning. I'm David Ferriero, the Archivist of the United States. Thanks for joining us today in the McGowan Theater for our FOIA Advisory Committee meeting. Today's agenda poses a question that is critical to the effective administration of FOIA across the government today and will only become more important in the future as we transition towards a fully electronic record-keeping work environment. How do we ensure that agencies can handle the ever-increasing volume of digital material and put that information in the hands of the public? I'm pleased to welcome NARA's former Director of Litigation, Jason Barron, as his insights about the implications of the capstone approach of email management and effect on FOIA will help set the stage for the committee's discussions. A uniting theme among the advisory committee's three subcommittees, proactive disclosure, search, and efficiencies and resources, is that technology has a profound impact on the way the government operates, as well as the public's expectations for openness. I look forward to receiving recommendations from the subcommittees on ways we can improve the administration of FOIA and continue to advance open government. As Archivist of the United States, one of my priorities has been to show how a small agency like the National Archives can not only contribute but lead in fulfilling the vision of open government's three principles: transparency, participation, and collaboration. And since 2010, the National Archives has made and delivered close to 200 specific commitments in our agency's open government plans. The National Archives has responsibility for critical components of the U.S. Open Government National Action Plans, including leading work to modernize record-keeping across the federal government and help agencies transition to a modern electronic world. OGIS is an important player in this work. This committee is the result of OGIS's first U.S. National Action Plan commitment. OGIS continues to lead in this area and has submitted 3 proposals for inclusion in the 4th National Action Plan, including a joint proposal with the Office of Information Privacy at the Department of Justice to continue to modernize the administration of FOIA. The National Archives submitted another proposed commitment for inclusion in this plan that is closely aligned with our recently released draft strategic plan for 2018 to 2022. The particular commitment to end the transfer of non-electronic records to the National Archives to the extent possible by December 31st, 2022 is part of our bold agenda to drive agencies toward full electronic record keeping and to provide agencies with the policies and processes they need to support a transition to a fully electronic record keeping environment. If you're interested in our draft strategic plan or have ideas about how the National Archives can continue to help the federal government reach new levels of openness, I encourage you to visit our plan on GitHub. Before I turn the agenda over to Alina to start today's meeting, I want to also thank Max Galka, founder of FOIA Mapper, a search engine for offline public records that promotes FOIA and government transparency, for coming down from New York to share his insights with the committee today. I don't think Max has arrived yet, but will be joining us. Thank you for coming today, and thank you for the committee's hard work. I look forward to hearing your progress. And now I turn it over to Alina.
Good morning, everyone. Thank you for joining us for today's quarterly meeting of the Federal FOIA Advisory Committee, whether you're here in person, via telephone, or via live streaming. As the director of OGIS and this committee's chair, it is my pleasure to also welcome you all to the William G. McGowan Theater and the National Archives and Records Administration. Believe it or not, this is the 6th quarterly meeting of this 2016-2018 committee's term. As you all probably know, members were appointed to this committee by the archivist and were tasked with collaboratively developing consensus solutions and recommendations that will be sent to the archivist and which will address some of the greatest challenges related to the administration of FOIA. As the committee chair earlier this year, I laid out a fairly aggressive schedule of target dates in order to ensure that the committee has sufficient time to fully consider all of the great ideas that are being generated by the subcommittees. I am very pleased to say you have all risen to that occasion and to that challenge, and I'm very much looking forward to hearing the committee's discussion today of the 3 subcommittees' draft recommendations. My sincerest thanks goes out to our 6 subcommittee co-chairs for your diligence in developing these recommendations, and to each of the subcommittee members for your valuable contributions to this work. I also want to take this opportunity to recognize Amy Bennett, our DFO, committee's designated federal official, who has been very involved with each of the subcommittees as they've worked through their proposals. I dare say Amy has been the glue that has held everything together and has ensured everything's running smoothly. So I'd love to give her a round of applause. Embarrassing, sorry. All right, we have a really full agenda today. I will try to move things along at a reasonable but brisk pace so we can get through everything. I am very much looking forward to our guest speakers and hearing the deliberations of the subcommittee's proposals and recommendations. Shortly, as I always have to do, I will go through some housekeeping rules, review our general agenda, and set some expectations for today's meeting. But before we do that, let's introduce all of the committee members participating in today's meeting, either via telephone or who are sitting around the table. We will begin, as we always do, with the members on the phone. I'll ask each of you to introduce yourselves, and please remind everyone of your profession and/or affiliation. So we should have Tom Sussman on the phone.
You might also want to mention he was calling in from a meeting, so he might not be able to.
Yeah, Tom was supposed to be calling in from a meeting. Amy advises me, so he may be not available yet. Do we have Jill Eggleston on the phone?
Yes. Hi, it's Jill Eggleston. I'm the Freedom of Information Act officer for USCIS.
Thanks, Joe. Do we have Michael Bell?
Yeah, this is Michael Bell. I am sorry for the background noise. I'm on I-85 south of Richmond, but I am the Deputy Director of the FOIA Division at Health and Human Services, as well as the FOIA Public Liaison.
Okay, thanks, Mike. Do we have Lynn Walsh? No Lynn. Okay, Jim Hirschberg, were you able to join us by phone?
Yes, James Hirschberg, Professor of History and International Affairs and former Director of the Cold War International History Project, George Washington University.
Okay, thanks, Jim. Is there anyone else on the phone that has not yet introduced themselves? Okay. Let's hear from those of you around the room at this table, starting with the end of the table to my right. So Nate gets to go first.
Nate Jones, National Security Archive.
Logan Perel from the Department of Treasury.
James Favell, Cause of Action Institute.
Raynell Lazier, CFPB, Consumer Financial Protection Bureau.
Chris Knox, Forensics Managing Director at Deloitte.
Ginger McCall, Department of Labor.
Michael Bekesha, Judicial Watch.
Margaret Cuoca, University of Denver.
Sarah Kotler, United States Food and Drug Administration.
David Pritzker, I'm the Deputy General Counsel of the Administrative Conference of the U.S. and also, at the moment, currently on temporary detail to the Ombudsman's Office at the CFPB.
Sean Moulton, Project on Government Oversight.
Stephanie Carr, Office of Secretary of Defense Joint Staff.
Okay, thanks, Stephanie. I also want to let everyone know Melanie Pastay will be joining us a little bit later in the meeting, around 11 a.m. We've saved her seat, so hopefully she won't be shy about joining us, so we look forward to that. Just a reminder for minutes purposes and making Amy's life a little bit easier, to identify yourself when you're speaking by name and affiliation. It helps her out a lot, so we're trying to help her. Please also keep in mind, and I have to remind myself this as well, there's a slight delay between the time members on the telephone speak and when the microphones in the room are turned back on, so we just need to wait a minute, which is very hard for me. I tend to be impatient. So administration, the committee provides a forum for public discussion of FOIA issues and an opportunity to provide feedback and ideas for improving the FOIA process. We encourage the public to share their written comments and suggestions with the committee, and to learn more about the subcommittee, about the subcommittee's work and the whole committee's work, and to submit public comments, please visit our newly updated website at www.archives.gov /OJUS. Is it now today behind me? Yes. You can also provide the committee with feedback by emailing FOIA/advisory/committee@nara.gov. At the end of today's meeting, we will have time for public comments, and we look forward to hearing from any non-committee members who have thoughts or comments to share. We are also monitoring Livestream. Joe Hudson from OJUS staff has been kind enough to monitor, and she will read them out loud if they come in during the public comment period. To promote openness, transparency, and public engagement, we post committee updates and information to our website, our blog, and on Twitter. The URLs are today, in fact, behind me. And you can stay up to date on everything that's going on in OJUS and the FOIA Advisory Committee news activities by following us on Twitter. I'm really encouraging everyone to join us on Twitter because I want to get our membership up. So please join us if you haven't. Information about all the committee's members, including biographies, all the committee-related documents, and public comments are all available on our website. We are live streaming this meeting. We will make the video transcript and meeting materials available on our website as soon as they're available. It usually takes about 30 days, so please bear with us. We will take one 15-minute break halfway through the meeting at approximately 11:30 a.m. During the break, you may wish to purchase food and or drink at the Charters Cafe located on this level. No food or drinks back in the auditorium. I have to always remind everyone that. There are restrooms directly outside of the theater and another set downstairs near the cafe. Before we begin our very ambitious agenda today, I just want to spend a few seconds laying out what activities we can all expect between now and the end of the committee's term, which is fast approaching, April 2018. During today's meeting, the full committee will have the opportunity to deliberate on the draft proposals and recommendations developed by our three subcommittees: search, efficiencies and resources, and proactive disclosure. Our expectation is that after this meeting, the subcommittees will reconvene as necessary to incorporate feedback they each receive so that the full committee will be prepared to vote on these recommendations during our next session scheduled for January 16th, 2017. Note, by the way, that's going to be a Tuesday, not a Thursday. Once we have a complete set of approved recommendations, they will be incorporated into the committee's final report, which we will vote to approve during our final meeting scheduled for April 17th, 2018. With that, I am going to move on to approval of our July 20th, 2017 meeting minutes. I believe that everyone has had a chance to review a copy of the July 20th meeting minutes. All comments have been received and incorporated. I have certified the minutes. So I will entertain a motion to approve the minutes. Do we have a motion?
So moved. This is Ginger.
Thank you. Do we have a second?
Second.
Thank you. All in favor?
Aye.
Okay, aye on the phone, good. Anyone opposed? Okay, the minutes have been approved, and they will be available for public inspection on the committee's website. Next, I would like to invite the National Archives former Director of Litigation, Jason Barron, to join us on the stage. And in the interest of time, as he is making his way up, I will give him an introduction and tell you a little bit about him. Mr. Barron serves as of counsel in the Information Governance and E-Discovery Group at Drinker, Biddle, and Reith in Washington, D.C., and as co-chair of the Information Governance Initiative, a vendor-neutral consortium and think tank. Between 2000 and 2013, he served as my predecessor, the first appointed Director of Litigation at the Archives, and before that, as a trial lawyer and senior counsel for a dozen years at the Department of Justice, where I also had the pleasure of working with Jason. In those capacities, Mr. Barron played a leading role in the government's adoption of electronic record-keeping practices and acted as lead counsel in landmark cases involving the preservation of White House emails. Mr. Barron taught the first e-discovery course for PhD master's candidates in the U.S. at the University of Maryland's College of Information Studies and has taught e-discovery at the American University's Washington College of Law. He co-founded both NIST TREC Legal Track and the DESI, which stands for Discovery of Electronically Stored Information, and International Workshop Series. Mr. Barron is a lead editor of the book Perspectives on Predictive Coding and Other Advanced Search Techniques for the Legal Practitioner, in 2016. He has written over 80 published articles on subjects related to e-discovery and information governance and has made over 500 presentations worldwide. Today will be his 501st, I suspect. In addition to numerous other awards received while in public service, Mr. Barron is a recipient of the International Emmett Leahy Award for his outstanding contributions and accomplishments in records and information management profession, as well as the Justice Tom C. Clark Outstanding Government Lawyer Award given by the Federal Bar Association. He was prominently featured in the documentary The Decade of Discovery in 2014, which was actually shown here at the McGowan Theater, which tells the story of a government lawyer seeking a better way to search for White House email. The American Lawyer magazine named him one of 6 e-discovery trailblazers in its 2013 issue devoted to the top 50 big law innovators of the last 50 years. In connection with issues surrounding former Secretary of State Clinton's use of email, Mr. Barron has appeared on NBC News, Good Morning America, MSNBC, CNN, NPR, and has been quoted in the New York Times, Wall Street Journal, Washington Post, Time Magazine, and numerous other media outlets. Mr. Barron received his BA, magna cum laude, with honors from Wesleyan University and his JD from Boston University School of Law. Welcome, Jason, and you can take it over now.
Thank you, Alina, and thank you for reading my bio just as I wrote it. It is a tremendous honor and privilege to be here today before this committee and before the Archivist of the United States. I cherished my time as Director of Litigation at the National Archives between 2000 and 2013, the last 13 years out of 33 years in government, where I previously served as a Justice Department trial attorney with Alina Simo in Civil Division of Justice. What I'd like to do now, shall I click on this, or is there some magical IT person in the background who's doing that? Okay, so while that's being fixed, let me say that the work of this committee is I consider the most important work in government. When I served as a lawyer in government, I believed that I held a public trust and served the public at large to make sure that government was transparent and as accessible as possible. FOIA is absolutely foundational to that, even more so today than ever before, given the world of electronic records that we find ourselves in. I am going to give informal remarks here. I'm going to talk fast because I have a lot of PowerPoints, but I'm happy to entertain questions at the end, and I will stick around. What I'd like to do is just make some preliminary observations about electronic record keeping in 2017. I'd like to talk about the Archivist's landmark 2012 directive. I'd like to talk about Capstone primarily. The initial returns on agencies meeting the directive, which is M1218, FOIA access to digital archives. I'd like to talk about barriers and solutions, especially as a matter of technology, and then I'll discuss a couple of recommendations that I made in a letter that I've submitted to the committee, and I hope will be part of the record, an October 2nd, 2017 letter from the Information Governance Initiative, which I have the privilege of co-chairing. Okay. So at the archives, today's archives and tomorrow's archives is not what it was, what it has been since the 1930s. Yesterday's archival collections and FOIA, with respect to those collections, are filled with hard copies, filled with actual objects of electronic media in all sorts of types. And that is a large headache and a large challenge to deal with. I'm not discounting paper at all in this talk. There is still more paper than ever before coming into the archives. But we have moved on. And the world of 2017 is a world where virtually every record of the United States government, temporary, permanent, whatever, is in digital form. It's created digitally. And because of the directive that David Ferriero put out in 2012, it is going to be both managed in the future electronically and preserved at the archives electronically. And that's a profound change. one where the United States has led the way. As I was discussing with the archivist, Australia and the UK and Canada have their own initiatives, but this is the largest initiative that anywhere in the world exists, and we'll talk about it in terms of the directive and capstone policy. The growth just in White House email records alone starts with Bill Clinton, 32 billion, George W. Bush, 200 billion, Barack Obama, 300 million emails came in to the legal custody of the National Archives in 2017. And so the archivist is responsible for 500 million email records, plus additional records on social media, and plus every other type of record that comes from the White House and from the rest of government. In fact, because of the directive and the December 31, 2019 deadline in it, there will be billions of emails and other forms of electronic records coming into this archives starting after 2019, accessioned under record schedules and in conformance with the agreements and the terms of those schedules. And so over the course of the decade after 2019, there will be an explosion. And so the National Archives really itself will not be solely in the box business at all. It will be primarily in the service business to electronic records, and that is a sea change. That's also true of the rest of government. The question is, how many of these records, email and other forms of electronic records, will be accessible? They're not all put up. There are no email record rooms in government as part of FOIA. Email is part of the iceberg that's buried underneath. And so while there's tremendous strides forward in terms of putting data sets and putting important records up on the web, email's not part of that category. And there are billions of federal records in emails and attachments particularly, and other forms of communications from users that we need to pay attention, and FOIA is responsible, is the means, is the mechanism for public citizen access. So the question that has animated me for the last 20 years or so has been, how do we search? How do we find records? How do we find needles in a haystack for all the reasons? FOIA, e-discovery, investigations, audits. How do we do that? And how will the historians of the future do that? And the civil society at large. Can we efficiently access them? And there are some serious obstacles in the way, but we can make progress. A new era of government was put in by the Managing Government Records Directive. President Obama said proper records management is the backbone of open government. He was quoting David Ferriero in his memorandum of November 2011. That memorandum, which challenged the government to do better in terms of preserving electronic objects, has resulted in the following policy. That's a screenshot of the memorandum itself. The policy that was put out in August 2012 by David Ferriero and by OMB says this in important ways as a sort of a landmark document. There are two deadlines that are extremely important. One has passed. It's the second one here, the December 31, 2016 deadline for agencies managing their email. All of it, not just the permanent record stuff that will end up at the archives, but all email in an electronic format. And the deadline that is still to come, which is December 31st, 2019, where federal agencies are asked under the directive to manage their permanent records, those records that are appraised as permanent in record schedules, in an electronic format for eventual accessioning into the archives. This is a big deal. Now, from what I understand, there's a release just during this month of the latest 2016 Federal Agency Records Management Annual Report. I read these reports religiously. What the report says is that the analysis of senior agency official records management reporting data shows that that directive, the M1218 directive, is changing federal records management from paper-intensive, analog-based methods to a digital government. So it's a wake-up call to the FOIA community as well, that things are changing and that traditional paper processes are being switched to electronic processes at agencies. From that report, I won't read everything on the screen, but the trend line is clear. that agencies are reporting that they're meeting the December 2016 deadline in substantial part. There's general optimism about whether they will meet the 2019 goal. The printing and filing method is going down in terms of percentage. The amount of agencies that are email archiving is going up. And I would say that a substantial reason for that is because the archives has made it possible for agencies to do this via the capstone policy. In the strategic draft plan that Archivist David Ferriero has put out there for adoption, I believe it's still with OMB, what NARA is saying is that by fiscal year 2020, which is really just around the corner, NARA will have policies and processes in place that support agencies' transition to fully electronic record keeping. Now, when I read the words fully electronic record keeping, I automatically want to assume that agencies will be considering FOIA processes hand in hand with electronic record keeping. That's not necessarily the case, because my experience in government as an agency lawyer, as a Justice Department lawyer, as a NARA lawyer, is that FOIA processes are siloed in government. That there's a set of FOIA officers here, and there's a set of lawyers over here doing e-discovery and doing litigation, and there isn't routinely the opportunity for the two to get together and talk about the workflow processes for e-discovery and for FOIA. And I think there's something that the FOIA community can learn from what we as lawyers have learned. So, to go on, I believe that the present policies in government prior to Capstone in terms of saving email were largely failed. That's my words, not anyone else's. And the print-to-paper strategy doesn't work in terms of compliance. Very few people are fully compliant with NARA regulations that have been in effect on email since 1995. Backup tapes are not a record-keeping system, and so courts go to them to restore them in litigation, extraordinary circumstances, but that's not the way that one would want to store records. There's idiosyncratic electronic record-keeping of everyone. Or everyone around the table here may have different ways of storing their email and other forms of electronic records that they create. And the DOD 515.2 standard is an honest, good faith attempt to put some rationality behind electronic record keeping under certified methods. The problem is that it's both underutilized and it has an issue, which is that it depends on users to drag and drop content the way that it's been deployed in government. And from everything that I've made aware of in my time in government and afterwards in private industry, all of us are too busy to comply religiously with record-keeping policies. Compliance is a huge problem, both in the private sector and elsewhere. So we need a different approach. And what we came up with a number of years ago is Capstone, which has been well executed by the National Archives in pushing it out to federal agencies. It essentially is a different approach to records management than ever before for email, which is that it's not that every email is categorized by record series and put in a particular folder. It's that entire sort of big buckets of email of senior officials are considered presumptively permanent records of the United States. And all other email at an agency that's under Capstone is considered to be temporary and subject to now a general record schedule 6.1 for a 7-year disposition if it's a substantive record. Now, there are exceptions and there's some bells and whistles here, but that's basically it. And so that you can think of the top of a pyramid, that every agency, there's a Capstone accounts of some senior officials, whatever the number is. There may be other key staff members that are below the SES level or below the deputy secretary level or general counsel level that may also create permanent records, and so they would be Capstone accounts. And then there's everybody else. The point of Capstone is in large part to preserve email and attachments for everyone. It's a full capture policy, but you're only preserving a little bit of it permanently. So the very top of the pyramid is permanent preservation of senior officials' email, everybody else just for 7 years. That means by volume, 98% of an agency's email is going to be disposed of in 7 years. It's not. No one should take away that Capstone is save everything for the government. But what it does do is it mitigates risk because in the 7-year period under the general record schedule, there are either litigation happening or there are FOIA requests for contemporaneous documents, and the email is there at the agency to be accessed under FOIA for at least 7 years, and for the senior officials for more time than that. GRS 6.1, I won't get into. It's the general record schedule implementation. One key aspect of it, though, is that agencies have to submit who are the senior officials who are designated to have permanent records at each agency. And NARA looks at that and reviews it. And basically, there could be a Goldilocks principle here, is whether it's too few or too many in terms of the designations. But as far as I know, agencies have been rational so far in doing their designations. Having said that, I want to be clear, again, I want to emphasize this point that the percentage of Capstone accounts at NARA is very modest. It's 1.5%. There's something on the order of 50 to 100 accounts, and others in the audience could give you the exact number. But the fact is that Capstone is not all-encompassing for permanent preservation of everything at NARA or at any other agency. It's merely a way of saving the good stuff from senior officials that would make its way into FOIA requests that are of high visibility, and for permanent preservation of the nation's history of senior officials. And everything else is on email, is saved for 7 years and then disposed of. And so what do we have? We have, from my reading of SAO reports from earlier this year, I won't go through this list, but it's what we have is a grab bag of 100+ agencies adopting Capstone, either in full or making progress towards full adoption in fiscal year 2017 and beyond. And the numbers here, just to represent the number of Capstone accounts at a particular agency, you'll see that they're relatively modest compared with the thousands or tens of thousands of individuals that are at larger cabinet agencies. And there's another list here, and we can go through it. But the fact is that I'm very heartened that there was such a positive response to the Archivist Directive, which of course is out there, and it's a mandate that is sort of self-enforcing to some extent, except that the fact is that agencies need to report to NARA how they're doing, as they have, and ultimately are responsible to Congress and to their own inspectors general and others in terms of audits as how they're complying with government policy. NARA has a set of success criteria for Capstone, one of which is systems, and I'm only doing a partial slides of all of the success criteria here, but success looks like what I've highlighted in red is basically execution of disposition using Capstone-based or content-based record schedules, and the key word is automatic. The key word in all of this is that the government policy on email is changing to an automated way of capturing email rather than relying on people. And that's what Capstone is all about, by these sort of simple rules in effect about senior officials and others. Another part of the success criteria that is applicable to this committee is access. And so email records have to remain usable and retrievable through their life cycle. What success looks like is that email records are maintained in a system that preserves content, context, and structure, ensures they remain discoverable, retrievable, and usable. In other words, FOIA-able, in this context. And so there is a tremendous interest, I would think, on the part of this committee and the part of the FOIA community as to having Capstone be a successful vehicle for accessing a huge swath of government records that are presently more difficult to find given current record-keeping methods. Now, I have my, I'm not going to say alt success, I'll just say alternative success criteria. Did agencies really adopt Capstone or just implement forms of save everything policies? I think NARA should take a look at that. it's too easy to say we're saving everything and therefore we're Capstone compliant. What Capstone means is there's a records management on the front end of these email archives. We'll transfer guidance in 2019, compel agencies to provide public use versions of records without personally identifiable information. I'm going to get to that in just a moment. How do agencies cope with exponentially growing amounts of email records? Are they employing more robust search technologies? I'll get to that as well. And we'll narrow recommend seamless integration of permanent emails and other related permanent records after 2019. That's an open question. How are agencies dealing with FOIA now for email? That is of interest, and I would urge this committee to track what agencies themselves are saying in their certifications to NARA about implementation of policy, and there are other reports that are due under the directive, and to ask the question, which is, how much has Capstone, and the fact that agencies are saying that they are preserving what will be thousands, if not hundreds of thousands, if not millions, or tens of millions of emails, depending on the size of the agency, how are they actually responding to access requests at the agency? Have they changed their workflows? Have they changed their procedures? Have they taken into account? Now, I've talked around the world about the coming age of dark archives, and I'm not going to spend too much time on it because this is a FOIA meeting for federal agencies looking outward, not necessarily for the National Archives. But there is an issue with providing access, whether it's an email repository at an agency that's subject to FOIA, or presidential records at NARA, where FOIA kicks in after 5 years, subject to some limitations, up to 12 years. There is a problem, which is that we need to be smarter in the space, both in terms of how we search and the fact that there is sensitive information throughout these collections. So the windows for citizen access to dark archives, first, they're open data policies. Obviously, if the government puts up records online, that's a good thing. But there's the Freedom of Information Act, there's litigation, and those are the drivers of the space. Let me say, just before I go on here, which is that this is not a knock or a criticism at all, but the fact of the matter is today, you can't walk into the National Archives and ask for email from any White House, what I described. So going back to Ronald Reagan, which there was some email because of the Profs case that I was involved with, but through Barack Obama, which would be 5 years after the end of the Obama administration. But you can't, it isn't available. It isn't generally there. And the question is why? And there's volume questions and there's sensitivity questions, and they're both challenges to opening large blocks of email. This challenge is going to be the same challenge that agencies have with respect to Capstone because of the tremendous volume and the sensitivity of materials. And so one needs to think through the workflow processes at agencies as well. Just for a minute to spend time on this, screening records. The NARA's policy, which it has been traditionally that privacy with a small p means that NARA does not release records that are personal in nature, that contain sensitive details, until about the 75-year mark after creation, so that individuals are either not around or that the privacy interests are not there anymore. I have argued that that's too long in the world, and we should be smarter about how to open up electronic records coming from the White House and others. But we need to anticipate filtering sensitive content, and that means a whole discussion which does include FOIA exemptions, the 9 exemptions of FOIA, but also includes a broader discussion of personally identifiable information and a set of other sensitivities throughout records. For the most part here, I'm talking about unclassified stuff, but there's also classified stuff. So we need to sort of work through the problems in large collections and see what we can open given the best available methods. And FOIA is part of this issue, and research into FOIA exemptions and how to filter for FOIA exemptions would be on anyone's list. There is also the issue of types of sensitive content. There are social security numbers that are subject to regular expressions. There's other types of textual content that are sensitive and non-textual content in media that will be coming into the archives in the future. So there's a lot of ways to talk about sensitivities. Leveraging the Archivist Directive means to me that that there needs to be an understanding and a consensus at agencies that capstone policies mean that capstone repositories are subject to a reasonable search under FOIA. And if that is understood by the FOIA community, I think we can then make progress on the technology side. On the technology side, an information retrieval task, searching the haystack, my task is to find, as a lawyer, has been to find all relevant needles in a large haystack. Because when I'm answering a discovery request, I need to find any and all documents related to a particular policy. And so I need to have really good recall. I need to get all of the documents that are relevant, that are in a collection, and I hopefully have efficiency in terms of precision. That is, I'm not retrieving false positives. When I was at National Archives, more than a decade ago, the tobacco litigation consumed us for a couple of years. We searched through 20 million White House emails in the Clinton period in response to discovery requests of the tobacco companies, Philip Morris and others. The search took 25 persons, lawyers and archivists. It took us 6 months using keywords to do the search to come up with 200,000 documents that were initially potentially relevant, and then to work through them. We basically pulled up on CDs the documents back when I was working on that, and we didn't have a fancier platform. And eventually getting to 100,000 relevant documents and 20,000 privilege. That effort convinced me at the time that lawyers need a smarter way to do business, because it's one thing just to be handed 20 million, but if you now have 500 million at the National Archives after President Obama, and if agencies similarly are in the tens of millions under capstone, you need smarter methods than keyword methods. I think keywords is a perfectly fine way as a first approximation to things, but it isn't the best way that we know in the space. And what I urged when I was standing up in March here, and I urged in my letter, and I've urged to the archivists, which is that NARA pay attention, and that this committee pay attention to new methods in the space, which we lawyers talk about predictive coding or technology-assisted review. They go by a number of names, but they're essentially algorithms that separate out, that classify records into various categories. And so in litigation, you have relevant and non-relevant, and you basically train an algorithm to look at a set of documents, and based on that training set of documents, make predictions as to the rest of a collection as to whether it's relevant or not relevant. Similarly, we could use such methods to search through email to find records that are relevant to FOIA requests. And that is what I think is key here. I'm here today to urge the members of this committee to spend some time looking at the e-discovery experience, because it's absolutely directly applicable to the FOIA access question for government, which is to use smarter methods when you have requests that involve large numbers of documents. That it's going to be inefficient for a FOIA staff, even working with lawyers and with others, to go through hits based on keywords of hundreds of thousands of documents, when you can be smarter in this space. My law firm can take 500,000 or 1 million emails, and over a weekend, using algorithms and using training sets, can basically provide transparency to a client on the story of whatever the client wants to know, whether it's employment discrimination or harassment or something about a merger and acquisition or whatever the task is. We can provide transparency very, very quickly. And FOIA should act like that. It shouldn't be that an agency is spending a year on a keyword search with hundreds of thousands of documents. It should be that, not necessarily over a weekend, but there are software that is available that should be at least recognized by the FOIA community as out there. And so that's what I am urging as part of this conversation. I'm going to go past a technical discussion of predictive coding. Don't have time. It basically is clustering documents that look like each other's. That's not the purpose here, to say to give a technical lecture. I'm just sort of as a heads up that this is important stuff. It has been blessed, the methods of technology-assisted review using alternatives to keyword searching. Been blessed by Judge Peck in 2012. He's a leading jurist in the Southern District of New York. He says lawyers don't have to worry about being guinea pigs anymore for judicial acceptance of computer-assisted review. His opinion has been followed by dozens of other opinions in the space. And so in the private sector, corporations, it would almost be, it's almost approaching the day of that you are not fulfilling your professional duties as a lawyer to not at least give the option to a large organization like a Fortune 10, 2,500 company to use these kind of advanced search methods to save money. Because you could save millions of dollars using fast, efficient algorithms rather than doing manual or keyword searching. And in the government, because obviously there's a bottom line in terms of taxpayer cost, I think there's a responsibility to know something about these methods as well, and to at least ask the questions of each agency how much faith they have in algorithms and analytics for FOIA purposes. Now, there's a whole other discussion beyond Capstone. When Capstone was introduced, I would say that there might have been some resistance in some quarters, that it's a disruptive policy in some respects. And because you're taking all of senior officials' email and putting it in a permanent category, when we all know that a substantial amount of whatever we all do is not permanently valuable for the archives. And so that's a very legitimate concern. The artificial intelligence that's coming, NARA has recognized in their white papers on Capstone, what is coming down the pike is going to make automated categorization of records easier, and we may find ourselves in an environment where we can be more granular again. We can have record series again based on the fact that the software recognizes different classes of records. But we're not there yet. We don't have good enough glasses yet to do that on the technology side. And so Capstone is a very good first approximation to preserving government records, and hopefully combined with advanced search techniques and filtering will provide for accessibility of those records. So that's the future. So I have some propositions and I have some recommendations. Ensuring a complete record of governmental activities. My first proposition is that we should use these capture and filter technologies. I'm an advocate for Capstone being more inclusive, that includes other forms of records of government, not just email and attachments, for a complete historical record and access. Second proposition is to use automated methods, such as the technology-assisted review, to help in meeting both categorization of record requirements, permanent and temporary, as well as achieving better access results in FOIA. And a third proposition is that we should be promoting search techniques as soon as possible, taking into account sensitive content. There are difficulties in this space in terms of software recognizing all those forms of sensitive content. I am well aware of it, including the FOIA 9 exemptions. But we need to have this conversation going forward. I've talked about signal to noise, that analyzing Capstone's success in capturing truly permanent stuff. I think that would be worth putting on a research agenda. Appraising archival strategies for filtering sensitive content. I've talked about evaluating how well total capture has increased the right of citizen access to these records. I would like to see over the next 5 years after implementation of Capstone in the 2016 deadline, how well agencies are doing. Have their FOIA requests, their response times in terms of large requests, have they gone down? Have they been able to be more open and transparent to the public, given these repositories that exist? We should be capturing those metrics. Finally, my recommendations to this committee that were part of my letter, and I'll repeat here, I think FOIA staff and agencies need to understand what is a profound impact of the adoption of Capstone and the directive itself. We're at a kind of an inflection point for NARA. After 2019, NARA is going to be taking in digital content, and agencies will need to be putting their permanent records into electronic form that is accessible for NARA. So we are looking into the future, and the future is very, very close. And I think FOIA staff need to understand that. In my talks to ASAP and to other crowds, I think there is some awareness, of Capstone, and there's certainly a desire on the part of FOIA staff to be part of a process where they understand what agencies are doing. But this committee, I think, is properly charged with an educational mission as well. So FOIA staff need to understand the impact. FOIA staff should be urged to work with others at agencies, general counsels, records managers, IT staff, in understanding what kind of software exists at the agency, what have they done, what has the agency done in the cloud, and how searches are actually performed in litigation, and to see whether aspirationally FOIA staff can meet that kind of same time periods and same sophistication that some agencies at least have in the litigation area in dealing with their search requirements and the requirements in litigation. And NARA and the scientific community should be looking at R&D in these areas of automated categorization, of advanced search and filtering, so as that we don't get to a situation where you can't, you walk into the National Archives of 2050 and nothing is available because it's all digital and it's all inaccessible because some of it is sensitive content. And that shouldn't be the future. We should have a future where we are open, and I mean, ideally, from our own homes, from our own offices, we have a portal looking into the archive space and seeing a vast amount of records. I think that will happen due to the efforts of David Ferriero and others, but with respect to email and with respect to some types of government records, there's a long way to go. And so there's a presumption that it's not going to all be online. So that's the future. In 1 minute left, I'll say people like me, well, I walked away after 33 years in government, and there's a sunsetting here of older people in the workforce. It means that there is an opportunity here for the millennials among us, who are FOIA officers and records managers and archivists, to take up this call to arms, to use more sophisticated strategies, not think that their only mission in life is to box up records and put them in a cave somewhere. And NARA is leading the way there because of the strategic plan in terms of what's the future of federal record centers. So it really is a call to arms, and I think we need to work together as lawyers, as FOIA access professionals, records managers, IT, to promote this kind of access to the digital record of government in the 21st century. And so we need to have more meetings together. I think culture change is possible. I'm an optimist, and I would hope that this conversation can lead to something. I get no royalties from this book, but I urge urge at least some of you to take a look at it. There's 600 pages of content about predictive coding. There are many pieces that are at a entry level, and then there's some advanced pieces, and there's some information governance articles as well, and it's available out there online. I want to thank the committee for allowing me this opportunity to present these thoughts, and I'm happy to answer questions. Thanks very much.
Jason, thank you so much. I think that's very insightful. I took a lot of notes, but I want to open it up to questions. Nate wants to go first, please.
Thanks a lot. I and others have been doing a lot of work on FOIA searches with the FOIA search subcommittee, and hearing what you said gives us a lot to think about, but also solidifies nicely with what we found out by digging things. So for one example, of all the 100 or some agencies, some search emails pretty well in response to FOIAs. Some say we don't search emails in response to FOIAs. So it shows some people are doing good and some people have ways to go. But the question I want to ask, and you got into this a little bit at the end, but maybe spitball or speak a little bit more candidly about this, is the power of e-discovery for FOIA searches. And pretty much every agency we talked to said, yeah, we want to use it, but generally it's too expensive. We've had people on the committee that in response to FOIAs, they say, yeah, we could do e-discovery, but generally they don't do it until they get sued for a FOIA lawsuit. They can't do it on the front end. What do you think are the prospects of FOIA shops being able to either afford or develop their own or affordable e-discovery. I guess I'm saying that it's a powerful tool, but most people say it's most FOIA people say it's too expensive. Is that true? And is there an optimistic way that FOIA shops can effectively harness this power?
Right. There certainly is a need for that conversation with agencies. If the agencies, I would like to think that a mature approach to e-discovery at an agency is to realize sort of structurally that they're going to get sued in litigation a lot, and that they would have software, they would have the licensing in place year to year that allows searches to be had. It's not a one-off thing where I get a lawsuit and then we have to go out and buy software. The procurement process under the FAR is difficult to get through if that were the case. But so many agencies who know that they're targets in litigation on very, very interesting matters that they're involved with and controversial are building platforms and having licenses to use particular vendor software. I don't really understand why a conversation in an agency couldn't take place where you build out those licenses or those seats to use the same software by a FOIA officer. And so it's an add-on. I'm not discounting that if you're starting from scratch, software is expensive. And the methods I'm talking about only kick in their value if you're up in the tens of thousands of documents. And so, but there's kind of a 90-10 principle on FOIA anyway, which is that, and in litigation, which is that the biggest lawsuits take 90% of resources, and then everything else is, 90% have 10% of resources. Similarly, at an agency, if you had a very large FOIA request at a large agency, you'd hope that if you had Capstone, that you wouldn't just be relying on keywords, that you'd be relying on something better and more efficient. And so I would build on the licenses that the agencies already have.
Ginger. This is Ginger McCall. Do you have a sense of what the cost would be to build on those licenses? And also the e-discovery software, is it something that the average FOIA officer could learn or be trained to use fairly easily, or is it something that requires specialized knowledge where a FOIA officer would have to work with an IT person every time that they were making use of that software?
I think it would be enormously valuable for a FOIA officer and for lawyers to understand how to use the software, not just rely on IT. You need to have hands-on. In fact, there's a professional obligation on our part to know what's going on under the hood to some extent and to actually have hands-on in the process. I don't think it's very difficult. There are vendors everywhere. If you have a vendor fair that here at NARAN, I know that you're participating in one in GSA on record keeping, but if there's a vendor fair for FOIA and for e-discovery and you're inviting the private sector in to have that conversation, you'll learn quickly that anybody can be trained in a day or two or three on a basic level, and then you have more advanced training. Secondly, that conversation is worth having about cost, and I'd rather talk offline about specific dollar amounts or whatever. But I think this committee could ask for in an RFI or in some format to ask the community what actually the cost would be for implementation of using these advanced methods. And my understanding is that it's not going to break the bank, but again, it would be a decision for each agency to make, and some are the scale and size and volume of what they have in Capstone will make it worth it if you're looking at FTEs spent on actually processing FOIA requests.
Logan Perel, I had a quick question for you on some of the, I guess, where the predictive coding would come in on a very, very large document request or something like that. Have there been any scientific studies kind of comparing that to keyword searching and human-enabled versus the predictive coding to see where they come out and which one's better at the end of the day?
So I'm really glad you asked me that because that's where I started on this, which is that I really wanted benchmark studies. And so in 2006, I was working with some academic types to basically use NIST as a platform for finding the answer out on these kind of questions. And the TREC, legal track that Alina has alluded to is a source, and we can get you links to that. There are multiple studies now out in the e-discovery area showing that advanced search methods are at least as good as anything else out there. We know one thing, however, they're hundreds of times faster. So whether or not, in terms of accuracy, if you're as good, but you're able to do something in a weekend rather than 6 months, the tie goes to the speedier. I think Judge Peck and others have read studies from the TREC legal track and from other noted experts that have carried on the work as saying that technology-assisted review is more accurate and more efficient. And so you can look at the studies themselves. I think we know where the world is going, and we're not going to be taking a step backwards using these methods. We'll be taking a step forwards in terms of having more responsive documents in response to trained algorithms and more efficient processes.
Anyone on the phone have any questions? I want to make sure I don't leave you all out.
Yes, James Hirschberg here. I learned a lot from the presentation about this daunting problem of electronic records, but I had one concern. You mentioned a time limit of 7 years to determine permanent records, and I think you stated that other records would be disposed of. My concern is that for agencies that deal with a great deal of classified information that is relevant to history and historians, like the CIA, like the State Department, much of the most important material is not declassified for 20 to 30 to 40 years or even longer. And so you can't really make a determination about what's going to be historically important in terms of lower level records. So is there any way to preserve a much larger amount of materials for a longer period, at least for agencies that deal heavily with classified information? Because otherwise important material could be disposed of in 7 years, and then it's only realized that it was historically important much later.
Right. Well, the concern is extremely valid. The capstone policy is an email policy. It's not a policy for all government records. And so any of the records in an intelligence agency that are classified that are outside the email channel are under existing record schedules, and they will be preserved for the time periods that NARA has appraised in those schedules, some of which are many decades or as permanent records. So we're talking about email when we talk about capstone. With respect to email, the issue generally for the government, and I'll put aside an asterisk for the intelligence communities, but the issue generally for the government is that are we getting those email records preserved under policies that say print out and put in a file somewhere? If you were satisfied that all such email records that are appropriate for preservation were put in files, then there is a legitimate question here. But I think what the capstone policy does is it presumes that senior officials' emails are permanent at the intelligence agencies, and they will be preserved, and that other individuals' emails will be under either a general record schedule or a schedule submitted by the agency. And so there's a conversation to be had with NARA as to whether the development out of agency schedules covering non-capstone accounts on email are worthy of further preservation beyond the presumptive 7 years in the general record schedule. But the bottom line here is that capstone is going to produce for the FOIA community thousands, tens of thousands, hundreds of thousands, millions, tens of millions more emails and their attachments preserved than I believe any agency would have preserved before under prior policies. And so it's a net win for historians out there in terms of capturing a huge swath of what the government is doing in terms of its communications amongst itself.
I would just add that as the Iran-Contra affair showed, often at the operational level, email records are not preserved on paper, and not only the intelligence agencies, but the State Department and the White House National Security Council staff are examples where not only the most senior officials' records, but operational level records could be of important historical value. So I don't know the technical and financial questions involved in longer preservation, but I would just urge that some consideration be given to something well beyond 7 years for agencies where historical value might not really be so easily determinable in only 7 years.
I am sure the people at NARA who are in the room are listening, and that conversation is worth having.
Thank you.
Sean, looks like you have a question.
Yes, Sean Moulton. I was just wondering if there's a process by which, when capstone accounts are identified, if there's a process by which the public or outside groups get to review this and see whether or not they think there are accounts that should be added to that are missing from that list, or any process to nominate that back to the agencies.
I would defer to the experts here, but I believe the notices are publicly available. So agencies need to file a notice with NARA as to who they've designated for capstone accounts, and those are publicly available. And so I think that's the answer. And of course, agencies get challenged in court sometimes, and there are other ways to bring up criticisms of what an agency has designated.
All right, anyone else have any other questions on the committee? Anyone else on the phone? Okay, I think, Jason, we very much appreciate all your insights. And we have a lot to think about, so thank you very much. Okay. I believe you're going to make your PowerPoint available afterwards, and so we can share that with everyone. And
I will. And I should say that the remarks I've said here are my own. It's up on the screen, and for those on the phone, and not any institution that I'm affiliated with, but I'm happy to put the PowerPoints up.
Okay,
So,
thank you again.
Thank you.
Okay, so a little off schedule, but I'm going to move on, and we're now going to turn to our subcommittee reports. I'm very excited to hear about that, from searches, efficiencies and resources, and proactive disclosures. I'm going to ask each of the subcommittee co-chairs to present an overview of their recommendations, and then I'd like to open up the floor to the full committee to provide feedback, ask questions, et cetera. And during the proactive disclosure subcommittee, we will also hear a presentation from Max Galka. Is he here? Hopefully he will come. Is he here? No. Okay. Otherwise, we will continue on. But Margaret Cuoco is going to be introducing Max. So let's move on, and we're going to hear from the search subcommittee first before our break. So I'm going to turn it over to Nate and Logan.
So I feel a little bit like Alina with her housekeeping minutes that she has to say every time. Before we get into search, I just want to say something important, that one of the recommendations from the last committee, that OMB update its 1987 guidance on fees that existed before the email, still is percolating, or maybe not even be percolating. So I guess I just want to note that if we want these recommendations that we've worked so hard on to be taken into effect, we still have to make sure, and we can talk offline or here, the best way to make sure that our old recommendations are taken effect, because we don't want them to be ignored. Maybe someone's working diligently behind the scenes, I'm not sure, at OMB. So moving on with the housekeeping, on to searches and our new recommendations. So Logan and I in the subcommittee on searches worked hard and learned quite a bit about FOIA searches. And if anyone is just now getting interested in it, I would say one good place to start might be the survey that POGO and the National Security Archive put out that interviewed lots of agency officials that spoke really candidly and showed a look under the hood of how searches are performed. And that's one general point before I get into the recommendations is we learned that there's a whole lot of information about FOIA searches that is not publicly available. And even for us that understand FOIA pretty well, and even with people speaking candidly to a non-government organization, there's not very much reporting on how agencies conduct searches, and without this information, it's hard to find best practices and see what's working and what's not working. So, with that point, it moves into the first point that I want to make. And I will try not to just read from the paper, but this one is pretty important, and it's a concrete step. We recommend that the Archivist of the United States request that the Department of Justice, OIP, collect detailed information as part of each agency's Chief FOIA Officer report regarding the specific methods and technologies that agencies are using to search their electronic records, email, in response to FOIA requests. And I think the point of that is to have in paper actual data from all agencies so that, as I said, we can see what's working and what's not working. I'll let Logan go on to the next points, and we'll let people from the subcommittee speak and then briefly discuss after.
So I think just want to reiterate Nate's point there that just we couldn't find data, and we thought a great place would be in the FOIA reports that OIP collects every year, and that way future subcommittees and committees and the public could go through and look and kind of see the disparities, and then maybe we could find the best practices from there. But if we don't have the data, it was very hard for us to make a recommendation, which is why we said, well, maybe we should just collect the data first and then see where we are. So do you want to open that up for discussion first, or should we just continue through to the next recommendation?
Melanie Pastay from DOJ. Did you all look at all the data we have collected on through the question on technology with the Chief FOIA Officer reports? Almost from the beginning, we've been asking agencies to describe the types of technology they have, whether there's impediments to getting technology, if they're happy with the technology. The agencies have been reporting that every year. So I'm trying to get a sense of, like, what is it that's different? What is it about? What was lacking from that you feel like you need?
Specifically on searches, and please circle back and show us, but we looked pretty thoroughly, and we can't tell how. So there's nothing saying, Agency X, how do you conduct a FOIA search? And we found nothing saying, well, we found it kind of whispered to us back channel saying, well, we go to the subject matter experts that's across the country, and sometimes they put it at the bottom of the desk and it's lost for 2 years, and then it comes back to us and our stats look good. And I've heard they said to POGO that we call them and they don't answer, and we have no way to make people give us the documents that they have. Or we found no information on the positive side saying we have a really snazzy program X that I just type in search for XYZ and it gives us 200 hits, and then we get it out the door and it's great. More agencies should use it. That's what Logan and I have not found that we're looking for.
Yeah, I think the most detailed information we officially received was kind of from the OIP presentation we got on how that works. So I think we were looking at that level of detail. We looked at the reports, we looked at the NARA records management, self-assessments, and I think just the level of detail of what the technology is and how it's being implemented is what we were trying to drive at. So we can move to the next recommendation. So the next one is something that Jill, who couldn't join us but is on the phone today, kind of brought to our attention. We wanted to kind of emphasize cross agencies, which was that DOJ came up with performance evaluation standards for federal employees involved in processing FOIA requests, whether you be someone who's doing FOIA searches and providing that to your FOIA officer, or FOIA employees processing the records. And really the heart of this recommendation is to see if we can get across all federal agencies, federal employees who have FOIA responsibilities in any way, shape, or form, to be rated annually and held accountable based on their compliance with FOIA. So that was where we were going with the second recommendation, try to make that standardized and cross-agency.
And Logan, you'll be coming over to OGIS on detail to help us with that, right? Just want to make sure.
And I'll go through the next one. The next one, I think we're looking for more full committee feedback on this, kind kind of spitballed it out, but the kind of point behind the third recommendation was we're not seeing a lot of FOIA offices deeply integrated with technology offices. And so maybe this is something that needs to be done on an agency-by-agency basis, but we thought at a very high-level cross-agency, we have the great Chief FOIA Officer Council, but we also have the Federal CIO Council, and they're not integrated, they don't talk together, so maybe we thought if they formed a joint subcommittee, they could look at cross-agency technology and FOIA issues and kind of keep going on the committee's work because they can really make recommendations and implement things where the committee, has a gap, basically. So that was the third recommendation.
So, and I'll note that thanks to Amy, I think Alina was right to call her our glue. Is that the quote? These three, I think, were well crafted to say this. We recommend that the archivists recommend that this person do that, and if that happens, if the archivist agrees, those hopefully will be able to crack the whip and see who's doing what or not doing what. The next recommendations we know are more just general best practices, and if there's a way that we can get a hook to get someone on the hook to force them, great. But as of now, we felt that it was important at least to share what we found, and so that if there's an agency, folks at agencies aspiring to improve their search practices, they can look to there and at least point to these. But just to reiterate that the first three are clearly actionable items. Increase the ability of FOIA offices to procure technology to aid federal agencies to more efficiently conduct record searches to the greatest extent possible. And under the text that I'm not going to read out, part of this may be we were careful not to do a one-size-fits-all agencies approach. One thing we learned is that there's all sorts of different agencies that conduct all sorts of different searches, but greater centralization may be an option at some agencies. I gave the example that I think happens all too frequently is that the FOIA offices are siloed from the records. And I understand that there may be national security or privacy or other concerns, but too often there is a huge universe of records that are not searched timely in response to FOIA requests just because the people that hold the records are doing other jobs and they're fighting forest fires and they don't have time to search in response to a FOIA request. It is possible and may be possible, and we would like to increase to the greatest extent possible that the person whose sole responsibility is FOIA to be able to search more records so that this delay lag does not occur. I think we've spoken before, and I'll just highlight one more time, that the reason this is important is because probably, in my opinion, the biggest cause of FOIA delays is FOIA searches. And it's often because not always, often because the subject matter experts do not search in a timely manner. FOIA people that have OGIS and OIP breathing down their neck, if they could search quicker, they would, and we want to make it so they can.
Our next best practice that we kind of highlighted, I think we just had a great presentation on, which is to make sure that emails can be searched electronically by FOIA offices. We have instances that I know where I've come across where we've had to go through paper printouts of emails, and that's obviously not an efficient way to conduct a search at all. So I think the general recommendation for all agencies is to make sure that there's electronic archival and retrieval of emails for FOIA searches, and that's something I think we've seen a trend of agencies moving towards, but we want to make sure that every agency has that bare minimum electronic capability to retrieve email records for FOIA searches.
Sure. The next one is pretty simple because Jason just did a good job making the case for it. Weigh the benefits of using e-discovery tools to conduct more accurate and timely FOIA searches against the potential legal costs of untimely or inadequate FOIA searches. And what we're trying to say is find a way to use e-discovery. I think what we've seen is pretty much every search expert we talk to, I think generally, in my opinion, says, yeah, e-discovery is generally the quickest, best, most thorough way to do searches. The problem is it's too expensive. So if we go into the text, it's hopefully in the future agencies or a nonprofit or something can develop a way that, or maybe it is affordable, we can talk, but find a way that agencies, FOIA shops, not just litigation shops after they get sued, can harness these powerful tools, which in our experience have great potential but are not being harnessed enough by FOIA shops.
kind of the last best practice that we wanted to recommend and highlight was, first, I think you have to have FOIA personnel office trained on what the agency records are, where they are, how they're located, and then those folks need to be able to communicate with requesters to explain that so we can have better crafted search requests that people can actually respond to. I think one of the big hurdles where we've seen it take a very long time for searches to be conducted is when these broad, winding requests and the person really wanted something narrow, but they didn't understand that the agency kept these types of records in this system in this way. And I think the more transparent that agencies can be in getting that out there and explaining that message, the better requests will be, the faster the entire process will work. So we were really hoping to make a recommendation to kind of front-end that process on how agency records are maintained and how they work. And that may include, in some agencies, getting the FOIA personnel who are siloed and off to the side up to speed, or just getting that information on a website so that the requesters can understand and that there can be that back and forth. I think that was our last practice, best practice.
And then if anyone from the subcommittee wants to bring up points that Logan and I missed.
Jill, anything you want to add?
Great job covering all the recommendations.
All right, I want to open it up to the full committee. Questions, comments? Sean.
Hi, this is Sean. So I was wondering, I think these are really good recommendations. One of the things that struck me is your first recommendation to have OIP collecting more information. I was wondering if the 4 best practices are a good set of topics that you want that specificity. I mean, there is the technology question right now, but it's open-ended, and then you lay out these best practices. Maybe that could serve as a structure for the types of questions or guidance that they give to chief FOIA officers in the future, that these are the areas we want reported on each year. Was that a thinking, or?
I think that's a good point. I also want to be clear that we understand that reports to OIP can be a burden, and we don't want to overwhelm people with doing reporting when they can be closing out requests. But we do think that it's really important information, and Logan can, I think, back me up that this report is the best vehicle to discover the chief, what is the chief cause of FOIA delays with better reporting, and I think that's a good idea to loop that in. I do want to be a little bit careful of not requiring too much information.
I mean, yeah, I think at least 3 of them could easily be the questions that we craft and work with Melanie to kind of get in the OIP report so that the data is there on those. And then we could follow up subsequently to see, once the data is collected, who's doing the best practices and who isn't.
It's Chris Knox. Addressing the cost issue, frequently FOIA is a precursor to litigation, and where we're finding the fact that FOIA is run completely separate from OGC and the litigators. You go through this the agency goes through this entire FOIA process, cleanses the information, sends it out. They go through the exact discovery process during the FOIA retrieval and production. And then when it comes time for litigation, OGC goes and does the exact same thing. And they do it in separate tools. They do it in their e-discovery tools. In terms of cost, yes, it's actually an added cost for FOIA, but if the FOIA officers could align better with OGC and actually convince OGC that this is a precursor to litigation, that it ultimately will go into the same system and therefore will save costs down the line, significant costs in any litigation that began as a FOIA. So that's just talking points to start trying to generate those conversations.
I think that's a great point. One thing another sub-point that I would just add, why isn't this happening? I think part of the reason it's not happening is because I don't want to give the impression, I think far less than 1% of all FOIA requests ever become litigation. So there's some thinking of agencies saying, oh, I don't think this person's going to sue, so we're not going to use e-discovery for them, which is not proper in my mind. But
that's far less. It's far less than 1% across all FOIA requests. But for certain agencies, it's a higher percentage. Mm-hmm. It's not 98%, but it's a higher percentage. And those agencies probably have an easier conversation to have.
Yeah, I think from the data that we have been collecting and the Chief FOIA Officer reports on, you all know we're big fans of e-discovery tools. And remember the days when there was no such thing. But the bigger agencies that do then tend to actually have a higher percentage of lawsuits do use e-discovery tools. DHS, DOD, DOJ, they do have the tools. And I just want to, they don't normally, it's not that it's a twofold process. Oftentimes why the tools are getting used in the context of litigation is because the lawsuit was filed before the records were processed. And so for the first time they're being processed, and now that they're in litigation, the e-discovery tools can be used. So it's not that they're doing double.
This is Sean. I mean, on the e-discovery, I think I certainly want to. I think you're right to strike that balance about the cost that we hear about in terms of using these tools. But I was wondering if we might sort of push the language a little bit. The way the benefits feels to me like a little bit of a consider this is our recommendation. I'd rather see it be more of a maximize the use within cost constraints. I mean, acknowledge that there are cost constraints that every agency is going to face, but that they should figure out a way to maximize this useful tool and still have both in there, but maybe a little stronger.
I think that's a good idea, and we'll take it back to the subcommittee would be the right way to do it.
Amy has a comment.
I was just referencing to Alina that in one of the OGIS reports that you might find interesting, we looked at the Immigration and Customs Enforcement, and they very much made a case to their management about increasing their expenditures on FOIA processing, including purchasing very expensive e-discovery tools, specifically so that they could reduce their exposure to litigation. And we saw that as their spending on FOIA went up, their spending on litigation did significantly decrease and in fact outpaced. So they ended up saving money by spending more on e-discovery tools.
Amy, which agency was that?
ICE.
It's on our website, the report, yeah.
Thanks.
Before my time. Anyone else have any questions for the search subcommittee? Anyone on the phone? I want to make sure I'm not leaving you out. Oh, David.
This is David Pritzker. I have one question. The first couple of recommendations here are addressed to the archivist and what's supposed to happen. But the rest of them seem to be identifying best practices. To whom would they be, to whom would these recommendations be addressed?
Well, I think it's a bit imperfect, but it would be for, perhaps you could say, for the archivist to publish the best practices. And the fact of the matter is we can't tell agencies do these. We can only say, here are what we've found. And if an agency is a poor FOIA agency, they're probably not even going to read this or accept them. But if an agency is a good FOIA agency and is striving to improve, they'll read them, hopefully implement them, and also they'll have the case to make to agency heads saying, here's what the FOIA Advisory Committee said we should be doing, and we're not doing it. I think we should try and do it more. So while I realize that there's not quite as much stick as we like, and I think Logan and I would be the first to say if you have more sticks that we could use, give them to us. That's the reason for that we're publishing best practices.
I think we're open to ideas. If you have recommendations for specific people we can recommend do something to implement them, we'd love to hear those ideas.
All right, anyone else? Are we ready for a break? Okay, let's take a break. Thank you very much for that report. And if anyone has any other questions, they can ask you when we resume, right?
Yep.
Okay. So 15-minute break. Again, a reminder to take an opportunity to visit our Charters Cafe. I'm not making an advertisement for it, but it is available. Please do not bring any snacks or any other edible items back in, and there are restrooms available there and right outside the auditorium. So let's come back at 11:47. Thank you.
I don't know. I mean, I think we'll have to see what the time is.
No, that'll work perfect. Then I'll do the intro, I'll do the.
So we'll just have to see, but I'm happy to do whatever you need.
Survey, so it's not official.
Without reading it.
Yes. Just say, don't use my name, but here's what we do. If that makes sense.
No, it does.
Usually they try and.
Just because I know.
Yeah, we kind of
push hard to keep that.
Yeah, I know.
And it may be the I don't know if Max is here yet.
Some agencies are doing it.
That may be some found time.
Look at every request. When we said, when this uncertain, we don't need to do the search, we can defend our search the whole agency. Screw it. We don't need to. What we did is reasonable. We just proved we have no records.
One answer could be recommend that the archivist circulate these best practices to all agency heads. It might be. Yeah. No, so even something as simple as saying recommend that the archivist promulgate these best practices or something like that.
Where it was for the reorganization.
Right. Right. Yep. Okay.
But I'm like, how would the FOIA office? There's no experience, no search.
Right.
It's the most random combination.
No, and I think that's a certainly good point. We'll get that in the next edition, I think, if the subcommittee agrees.
If your agency has one system, you know, for the FBI, and you can just put in a name and get everything back, that's great. But it doesn't work that way. In most of the places that it's just.
Hello, Caribbean. Hey, how are you?
Fine. Well,
No, I don't want to keep disturbing you.
You just get your.
It's an emergency.
hey.
I'm sorry. I was like.
This is my first Halloween candy of the season. So
I
I hadn't been to the grocery store yet.
Next
so
week.
I'm behind.
Craziness.
I got a little stash in there hiding my wrappers.
Do you? No, that's nice. You don't have to reach out for it.
Plus, I promised Michael that I would.
Yeah, and I showed up.
I think. And I had these from last year, from like Thanksgiving. So I said to Amy, I'm going to bring them. She's like,
The candy at first?
oh, no, the candy is fresh off the shelf. The little plastic bowls.
Then I figured out she must be
Yeah,
about the bowl.
It was the bowls. And Amy was very excited because she said, oh, perfect. We have black tablecloths, orange bowls. We're in the theme.
Yes, it's very fast.
It's all good. All right, so we're still waiting for Sean. Just trying to keep it.
I would say
guys.
I would say it was 4 to 5 of the large and the small, or the large and the medium.
Okay, so 4 to 5 of each.
Yeah.
So 8 to 10.
Because I was gonna say 10.
Yeah.
I think it was right.
I was like, let me not say that because I don't have anything to look at.
Okay, I want to welcome everyone back. Oh, is the mic on?
He walked around and clipped them.
Can everyone hear me? I can hear myself. All right, welcome back, everyone. Just want to invite everyone to take a seat, and so we can resume and stay on schedule because we have a lot to get through. We're now going to move on and hear from the Efficiencies and Resources Subcommittee. I will turn the floor over to Chris and Ginger. And I see Amy strategically seated the two subcommittee co-chairs of each subcommittee together, so that's great. So if you wouldn't mind taking it over, that would be great.
Absolutely. Can you hear me? Okay, there we go. First of all, we'd like to thank Amy again. She's not just the glue, she was the force behind us making this. I could show you my inbox of emails from Amy. No, really do appreciate it. As we mentioned in previous meetings, again, this is the Efficiencies and Resources Subcommittee. We were looking to drill out best practices among what we deem to be high-performing FOIA agencies, both large and medium. We eliminated the small size simply because they were mostly outliers in how they were doing things. So we looked at the mediums and the larges. And the way we identified a medium or large and the qualities that we took into account, they're in the meeting minutes from a previous meeting, so I'm not gonna run through those. What we did was we identified those agencies, we sat down as a subcommittee, and Ginger drafted a list of questions so we can consistently interview those subcommittees, and we strayed slightly from those questions, but for the most part used that list of questions. And then we held interviews with the individual committees. Everybody on the subcommittee had at least one interview with an agency, and we don't have the exact number on hand. I meant to look it up before we came in here, but we did somewhere between 8 to 10 interviews, about 50% large, 50% medium. So we had a sample set, and then we took the results of those interviews, put them all into one set of notes, and then drilled out themes and looked for common solutions that were working for multiple people, and we put those into 3 different buckets: management and process, talent and staff, and then technology. And then we put those observations, what you have in your draft is the observations from the combined set of interviews, and then the recommendations and the benefits from those recommendations. We're going to run through those really quick. I'm not going to go through every single recommendation because you have the paper in front of you, but we'll just highlight and clarify some. Some of these are going to seem common sense. Some of these are going to seem potentially expensive. We talked about the cost of implementing certain tools. But overall, we try to put together a good set of best practices that really could be adopted at most agencies. So first of all, I'll run through the management and process, and then Ginger will run through the talent and staff, and then we'll finalize with technology. So the first recommendation and observation is the importance of working with the requesters early on in the process. Multiple agencies that we spoke to said that clarifying early on, working in and I know it's an odd word, but partnership with the requester to get them exactly what it is they want, you can drastically narrow down your universe. We all know that. And then encourage teamwork. This isn't just among your team, but it's elevating FOIA to I don't want to use a mission because it's elevating FOIA to the level that the individual subject matter experts want to participate in it, and they want to collaborate with the FOIA teams. Also forming teams and creating subject matter experts. One of the things that Jason Barron touched on was using technology to cluster documents that are like-themed. If you have like-themed FOIAs and requests, you can create a subject matter expert in that can blow through them much faster. Again, some of this seems like common sense, but a lot of people aren't doing this. And one of the successful agencies actually looks across all their FOIAs that they have at a given time, and they don't look at them as individual requests. They look at them as a collective universe of information, and then they can break apart those requests and have a subject matter expert here that might touch all of those FOIA requests because there's a certain kind of document in all of them, and they only look at that and they just get stronger and stronger at those types of documents. Accountability, that's been touched on a couple of times. Some type of visibility and metricing system into the individuals that are responsible for providing responses, and that could be anything from pages reviewed to FOIAs closed. I mean, some of these metrics are going to be a little bit dynamic because FOIA A doesn't look like FOIA B, but pages seems to be a pretty good metric that some of the more successful agencies were using to evaluate their teams. And visibility into the success of those teams as well. Some, when we talk about technology in a little bit, but some ability to track at the individual level how those individuals are doing, so you can elevate everybody to higher performing teams because you can hold people accountable. Expanded use of tracks, actually consider creating a I'm sorry, hang on one second. I can't read my own note. This is really more balancing resources between simple and complex, not overwhelming an individual resource with continually complex requests, balancing the work between resources. And then centralizing, we've spoke a couple of times about centralizing, but centralizing where it's appropriate. You want to touch on talent?
So on the topic of bringing in talent, our first suggestion is to build a career path. And our recommendations for that, the first is to consider creating rotational programs to expose young employees to FOIA. This would help the agency to identify talent, and it creates FOIA professionals. It would help new employees to potentially see FOIA as a career path, which they might not otherwise see. To create a career model for information management. And I know I'm on the board of ASAP, and this is something that ASAP has been hard at work on. And it's certainly something we've already made some progress on, but it's somewhere where we could make further progress. Specifically, we want to align FOIA folks with privacy and records management folks on a similar level. This would help to create institutional knowledge of FOIA and create new FOIA and information management professionals who think of this as a career track within the government, not just something that they're doing temporarily. It's something that they would be more invested in then. On the topic of interns, detailees, and contractors, we found that a lot of the more successful agencies that we observed and interviewed were making use of interns, detailees, and contractors. So our recommendations specifically are to assign interns or temporary staff to complete straightforward or time-consuming tasks such as data entry. And these tasks require limited training, so it's a good temporary task for someone even with a low level of knowledge of FOIA or government systems. And this would be assigning temporary resources to these tasks, and that frees up more time for more experienced folks to be more focused on tasks that actually require their level of experience. So our second recommendation would be to contract surge support staff to increase responses rapidly and aid in routine review. And again, this just frees up full-time regular agency employees to focus on other things. It uses temporary staff instead of going through a potentially costly hiring process for a more long-term staff member. It allows agencies to assign resources as necessary and as time requires, and creates more flexibility for the agencies.
Thank you, Ginger. Moving on to technology, the first category is records management and search. And the recommendations that came out of those conversations, a lot of the conversations had to do with locating relevant material and aligning better with records management activity. Creating an add-on to the IT systems for actually getting the records out ensures the records actually can come out of the systems. Again, that might be common sense, but it's amazing the lack of ability that some agencies actually have. Designate a point of contact to approve the search requests within the records management systems. Ultimately, that improves the quality of the searches over time. Again, that creates the subject matter expertise, and it creates the single point of contact. Make the goal of responding to FOIA requests a major component when developing records management systems and workflows. This is better aligning with the upstream records management, the more information governance activity, the privacy and records folks, nagging them at the time of systems implementation to keep an eye out for FOIA keep an eye on FOIA activities that the system might be used for. The next was tracking systems. The recommendation was adopt a centralized department-wide FOIA tracking platform or consolidate to fewer tracking systems. Some agencies have none. Some agencies have multiple. Some track the same thing. Some have duplicitous information. Some track completely different information. Consolidating that into one tracking system obviously saves significant time in the long run and ultimately would make the FOIA reports at the end of the year easier. Employ an established commercially available or government available product, COTS or GOTS software product across the organization. We did not include specific names in here. There's many products and platforms out there, but implementing a product that's either specific to FOIA or a product that is very good in another category like e-discovery and is adopted for FOIA, and you build a FOIA workflow on top of that, because that's the last recommendation. If it's a COTS product and it doesn't meet the agency's need or the FOIA process need, then have a developer modify that and have them continuously adjust the system to meet your needs. Again, that's a little overly simplistic, but this idea that there are plenty of, we've talked a lot about e-discovery tools today. There's a lot of analytics tools out there. They work very well, and they solve a lot of the problems that we're trying to solve, but they don't speak the FOIA language. And instead of exemptions, they call things privileges and attorney-client. It speaks in legalese and not in FOIA-ese. That's not that hard to modify. It's putting a FOIA address on e-discovery tools, and it's not that difficult to do. And we talked about the 90-10, or Jason talked about the 90-10, that an agency that doesn't have a lot of complex requests may not see the value in implementing a technology like that. But if you have a lot of simple requests that look the same day in, day out, you can start to train a system like this to redact out. If it's forms, they redact out certain portions of the form. If it's PII, PHI, it can prescriptively redact out information. So if it's 4 numbers dash, or 3 numbers dash 2 numbers dash 4 numbers, I think that might be a social security number. I put a transparent box over it, then the person doing the work, boom, it's redacted. So even agencies with simple requests can benefit from these technology recommendations. And I'll leave that open for the rest of the subcommittee to make any comments. Correct me where I'm wrong. Thank you, Stephanie.
Okay, great. Thank you very much. I want to open up the floor to questions from the committee. You gave us a lot to think about. I was taking a lot of notes. Nate? Oh, I thought you. You're shaking your head. Anyone have? I actually just do want to note that at least one of the proposals Stephanie had a question about, so we should make sure that we cover that.
Right. There were just areas that we need to look a little more closely at and make sure that we have the right language.
Okay. I just noted there's a comment on the second page, right, or on the third page.
Yeah, we put this out as a draft to the subcommittee
Okay.
members at the 11th hour.
Right. Hey, at least you put it out. That's great. Okay, but that's something you can all work out within the subcommittee.
Right.
Okay, good.
Chris, I think that this is Melanie, I really think your last point was so interesting, that we do tend to think of the technology tools as being having the most impact for the big agencies with the massive quantities, which of course proportionately it will have a big impact, but it doesn't mean that they're not valuable for the smaller volume agencies, because even if there are, and a lot of the small volume agencies respond within the 20-day time period, but if we could get it down to 5 days, it's awesome. It's an improvement. So I just think it is a really good point. They're valuable for everyone.
Yeah, they're differently valuable.
Yeah,
but if you
still
can, in the smaller, more simplistic requests, if you can amplify that subject matter expert and they can do 10 times as much,
Yeah.
it pays for itself in the hourly wage. So.
Yeah.
Logan. Yeah. And then Sean.
So thank you guys for putting so much work into this. I had a suggestion that I kind of had an aha moment when I read the recommendation on contractors. Every FOIA office I've ever worked with has had contractors, and that always takes a significant amount of time for FOIA officers to get contractors in. So I had a crazy idea I wanted to throw out, which was maybe there's a recommendation to GSA to put in a government-wide contracting vehicle at the unclassified secret and top secret level, where agencies can just surge CLINs or task orders on that contract to get immediate surge support and not have to start the entire acquisition process every single time they need contractors. And I could see that as a government-wide benefit if that could be done.
That's a great suggestion.
Great. Maybe we can talk a little bit more after this meeting, because I'm less familiar with the process. It sounds like you have more knowledge of that.
You use words that I understand. I know those are words. Thank you.
Sean, did you?
Yes, I just wanted to follow up on Melanie's point about the COTS and the smaller agencies, and I was wondering, has it ever been explored, to your knowledge, that smaller agencies group together to go in on a sort of a purchasing of a technology and get licenses? I mean, I know it's usually in a single agency and the licenses get handed out, but for smaller agencies, sometimes it's that initial hurdle, and they just don't have enough sharing that they even do to make it economical.
I think it is an idea that I hear about, but I don't know how, robust it actually is in practice.
Okay. So you don't know of any examples where someone's tried to
do it.
To go in?
No.
Wouldn't that be similar to like the FOIA Online model? So it's
Yes, I mean, they built it, on top of an existing, so that's probably the best example.
Well, that's government-owned.
Right.
It is very similar, but if you're talking about a COTS going in together for a COTS platform.
Teaming up and buying like one set of e-discovery software
Right.
tools that everyone could use, for example.
FOIA Online can't do that for you.
Yeah.
Right.
Yeah, I don't know of any examples where but I know it's one of those things that people always talk about as cost saving, smaller people grouped together.
Maybe that's something the subcommittee can consider including.
Technology companies will follow the money, and if they don't think there's money in the industry, they're not going to break into it. I mean, there's a reason why there aren't companies banging down your door for FOIA technologies right now. So we got to figure out how to market FOIA better.
Yeah. We have the numbers.
We do.
I actually just wanted to add that this is Margaret Quokka. I wanted to add that on your last recommendation, or the last set of recommendations, including having a centralized FOIA tracking platform that would be common across agencies, that feeds very well, I think, into the recommendations that we're about to discuss, or at least one of them in the proactive disclosure subcommittee about FOIA logs, because if we had a centralized tracking platform, it would be easy to extract that data in a consistent way across agencies, which goes to one of the recommendations that we make. And so there may be opportunities for kind of cross-fertilization as we further develop the details of these between our committees.
Absolutely.
Sorry,
Sorry,
go ahead.
Ginger, go ahead.
No, sorry, this is Ginger. Yeah, I agree with you on that. I'm starting to hear themes between our recommendations and the search committee's recommendations, and I suspect that there'll be a lot of overlap with the proactive disclosure committee.
And that's actually an administrative question. At the end, are we doing one set of recommendations? I don't think we've really talked about, are we consolidating the subcommittees back and presenting one set of recommendations versus three? Is that what the idea is? That's what I assume.
That probably would be preferable.
If we do that, then we can start looking at the synergies across them. And
Right.
Yeah.
But I did want to I thought I heard you say recommending for a tracking system across multiple agencies, and I think the recommendation was really within an agency that they have a tracking system that works department-wide.
That was my problem.
It is currently, but it could be based on
Could be.
proactive
I just-
disclosure.
yeah, I
It
just
could be
wanted to-
adjusted a little
My
bit.
misunderstanding. I was feeling hopeful.
Please remain hopeful. Okay, anyone on the phone have any questions or comments they'd like to make?
Yes, this is James Hirschberg. Can you hear me?
Yes, loud and clear.
Can you hear me?
Loud and
Right.
clear.
There was some mention of metrics for measuring efficiency in the report, and that referred to closing cases and also number of pages released. And it occurred that those were purely quantitative measurements, not qualitative. I've had experience where many pages were released and they were all from publicly available databases. So the case was closed, many pages were, quote, released, unquote, but it was completely dissatisfactory. So my suggestion is, and this goes across the board for agencies, why not, when a FOIA response is sent out, shouldn't there be a electronic question, were you satisfied with the response to your request? And if the answer is no, why not? And collect data as to the percentage of respondents who were satisfied with the response and also the reasons for any dissatisfaction. And I think that could be incorporated into measurement of efficiency and productivity of various FOIA offices.
It's a really interesting point. In just ruminating on it in the 10 seconds I have, I would think that you would get because of the nature between the requester and the agency, that more often than not you would get a no. And that doesn't mean that the quality of the response was poor. So I think more often than not that wouldn't tie to the performance of the individual, which is what we were talking about here, versus the performance of the agency.
Right.
But it is something that, we should take into account as a possibility.
That brings up another point. This is Michael Bekesha. When you were interviewing people, did they talk about the different types of requesters? And they thought of efficiency was a commercial requester, a good government transparency group, or an individual requester? Because I think sometimes that changes about those early conversations.
The quality of the requester themselves?
Not necessarily the quality, yes.
I don't mean that negatively.
The
experience.
To the extent they
It's
kind
called
of know what
experience.
they're looking for versus not knowing what they're looking for, and how that affects the entire process.
I don't think we.
One thing
Yeah,
I noticed
absolutely.
when we were interviewing, I'm sorry if
No, please,
was that a lot of agencies say the most challenging requests, of course, are those requesters who seek any and all information on everything that you created on this particular subject. Those are most challenging to work with.
That was something this is Ginger, that we had identified, in particular with the Department of Labor. One of the offices that we had looked at initially was the Occupational Safety and Health. And OSHA deals with a lot of pretty professional requesters, pretty rote requesters who know exactly what they want. They want the investigation file from their company. That's what they want. And that tends to skew the numbers then for those agencies. Agencies that deal routinely with more professional requesters, more finite requests, those sorts of things tend to skew the numbers in favor of the agency performing better.
And it's not something that we necessarily took into account here. I'm not sure how we could, for a recommendation, have better educated requesters. We could try it, but it is an interesting point. It's not one that I really considered.
Because I think sometimes, I know especially for individual requesters, they don't know what component of the agency, they don't really know what types of records exist, and that's why sometimes they end up asking for any and all records, because they don't realize that email, there's a capstone program, so emails may be here, and they may keep reports here, and so they start asking because they don't know.
Well, I do think that falls under the guise of working with your requester, and maybe a component of that is educating your treating them like a true partner and educating them on what you have and what you don't have.
Yeah, it's almost like putting, and I think the search committee talked about it a little too, was like putting that information on the website. Like, these are the types of records this component would have. These are the types of records that could be asked for. So then when the FOIA request comes in, maybe it's more efficient. So you have a better starting point than the general any and all. And I don't know if that's possible in all agencies, but some agencies that see, as you were saying, very similar requests all the time, putting that information out there, if you go back to ICE and immigration files of people, saying like, these are the file numbers, these are the forms that are filled out. This is what you would ask for. It could increase some efficiency.
Yeah, I think that's an excellent point, and perhaps a good broad recommendation for the committee as a whole is to make public education a component of the recommendations that we make. I mean, OIP and OJIS certainly are engaging in a lot of public education efforts, but I think that agencies more broadly could potentially do a better job at that. That's Ginger, by the way.
I know, it always so funny you have to say our names. This is Melanie. The agencies are already required as part of their, under the FOIA, to put their reference guides online, and those reference guides, their FOIA reference guides, are supposed to have major information systems, but the idea, putting aside the scary title for it, exactly, they're required to describe the records that they maintain at the agency. So we have a piece of it, but I think that and so that, of course, that's helpful, but I think that there's just no substitute for the engagement with the agency as you're formulating the request, because people want specific things, and having that human, we're big fans of the human contact and being able to walk through with a requester. Well, did you know this was here, and if you ask for it this way or ask for it of this office, we can do faster, those kinds of things. So I think it's a good combination, but we do have a starting point for publication of records because it's already there.
Nate, just really quick, one of the sub-points that I didn't mention, our recommendation is instead of perhaps having that in page 20 of a PDF, just broadcast it right by the request button. Will make requesters make better requests and make people's jobs easier and hopefully that's the thinking.
And some of these things, I'll just give a tiny little preview, but for those of you who are following our work on the National FOIA portal, on GitHub, these are all things we're factoring into that, like helping the requester understand where to look first before making a request, and then to engage with the agency to formulate their request. So we're trying to build these concepts into the National FOIA portal.
I just had a question following up on what Melanie said, and I'm not sure if anybody has any experience, but if a FOIA requester calls the agency and says, I'm looking for these types of records, how would I send this FOIA request? Would the agency respond to be helpful, or does the requester have to send the FOIA request to be able to have that conversation?
Please call us. I mean, I get that all the time, and I'm thinking about I have some people this is Sarah Kotler, I have relationships with certain reporters or groups because they feel like I've been helpful to them in the past. And they'll call and say, before I submit this, I just want to make sure that I'm doing this in the right way, or maybe I'm not even sure if it's FDA, maybe it's NIH, let's talk it through.
That's great. Do you know if other agencies are that willing? And
anecdotally, I can say that labor does that. I know we work a lot with potential requesters who will ask us questions, this is what I'm interested in, and we'll work with them to try to identify that. I mean, that is theoretically at least, supposed to be the role of the FOIA public liaison.
Exactly. That's what I was going to say.
Maybe it doesn't always work that way operationally, but theoretically, that's how it is.
I was just going to say that when you think about it, and actually, in addition to the liaison, I always like to make sure people know, like the FOIA Requester Service Center, the front line, it's 2 tiers, that is their job, exactly, is to help facilitate the making of requests and understanding of the process. So we definitely would look at it as something that you are required to do. Not required to do in that sort of, harsh way, but that's a part of the process that helps all of us.
Yeah, and that person does liaise, I mean, at least at Labor, that person will liaise with individual subject matter experts. I mean, I've gotten emails about, we have this person who's interested in making this request, and we're trying to work with them to tailor the request. What do you think about this? So they do go up the chain to speak to people and out to other components of the agency to speak with experts on the subject matter.
And this is Sean. I do think, though, and I think a lot of agencies and more agencies, it's actually getting a lot better that you can have those discussions at a time. But it's mostly the experienced requesters who even know that they can do that they have the relationships with someone like Sarah, or they've been in contact with a FOIA office, and they say, well, let me check this. The new requesters or the infrequent requesters probably never really realize that or feel comfortable making that contact.
And this is Sarah. I mean, it works both ways. I mean, I always say that the FOIA officer's best technology tool is actually the telephone.
Yeah.
Because if I get a request, I can look and go, this person does not know what they want. And so it just makes so much more sense for me to pick up the phone. I'm not going to say, well, they didn't call me first, so we're stuck with it. It is part of my job and all FOIA officers' jobs to work with requesters and maybe let them know that maybe they haven't asked in the best way for records.
And hopefully with the features we're putting on the National FOIA portal, for the very first time requester, we're having things, pop-up boxes and things that explain if you make a simple request, it will be processed more quickly than a complex request. If you want help, we're actually saying that. So we'll hopefully the portal can be a way to tackle or address the new user.
I don't need to give a plug for OGIS necessarily because we're very, very busy, but that's certainly an important function that we fulfill as the FOIA ombuds, and we give a lot of advice to requesters. I've heard our staff assistant on the phone, giving instructions about you want this kind of information, you need to go to this agency. So we really do try to steer people in the right direction, and I think we're very successful at that. So I think promoting dialogue and talking on the phone, I completely agree with all of that.
If we could vote on that, we'd have a
nice
yeah.
We'd all be in
We
agreement.
all agree.
We all agree.
Any other comments for the subcommittee? Anyone on the phone?
Yes, this is Jill Eggleston.
Hi, Joe.
A couple of comments. One with respect to the accountability portion. I'm wondering if we should include in the performance standards not only a quality element in addition to a production element, but also a standard that addresses this requirement to communicate with the requester, whether that be in outreach or whether that be, in some other method. So that might be something that we'd want to include in an overall employee performance standard. The second comment I had is...
I think we're all busy writing, Joe. Thoughts on that?
She did say she had a second comment.
Oh, I'm so sorry. Thank you. I just wanted to make sure you didn't have anything to say. Joe, I'm sorry. Go ahead.
Oh, that's fine. And then secondly, with respect to the technology piece, to follow up on a previous comment, this is something that the search committee talked a little bit about, and that is perhaps making a recommendation to GSA to include a provision in the federal acquisition regulation, which would require that any procurement of an electronic system of records take into account FOIA responsibilities of the agency.
Does everyone understand that? Or-
I have some sense of what she's speaking
Okay,
about.
I was just gonna say whether you needed her to explain that a
I
little
think something
more.
like that might be included already. I know I was just looking at Privacy Act responsibilities last week, and that's included in the FAR. But that is a good question to look into, and it's something that I will try to track down. This is Ginger, by the way.
Great, thank you.
This is right now. As far as the first comment about the communication with requesters, I'm just concerned that that may already be an expectation. I believe that most of the FOIA standards speak to communication, oral and written communication, and there is a requirement that we send an acknowledgement letter. There are already these requirements that are already a part of the FOIA analyst's duty. So I think that maybe we want to not make it a strict standard that because in every request it may not actually be necessary, and it could hinder production on other requests if you're forcing the FOIA processor to reach out when it's just not necessary. So I think that may already be an underlying standard. I think that we've acknowledged that it's a benefit, but it can be, a detriment if we make it a strict requirement. So I just wanted to throw that out there. We'll certainly talk about it in the subcommittee, but that's one thing that I think may be already being addressed.
Okay. Thank you, great point. Thank you. Anyone else? Again, anyone on the phone? Have any other comments? Okay. All right, I think we're ready to move on. So I want to turn it over now to our last subcommittee, last but not least, proactive disclosures. And I'm going to turn it over to Margaret and Sarah. Margaret, I believe you're going to.
Yeah, let me, so we actually have a guest speaker speaking to one of our recommendations or about the subject matter of one of our recommendations. So we have 3 basic set of recommendations that we circulated, which we'll briefly go over after our speaker. But I want to quickly, because of time constraints, introduce Max Galka, who is a data scientist and entrepreneur based in New York City. He's the creator of FOIA Mapper, which is a search engine for offline public records funded by the Knight Foundation. Max is also an adjunct lecturer at the University of Pennsylvania, a bi-monthly columnist for The Guardian, and a writer of the popular data visualization blog Metrocosm. So I'm going to turn it over to Max first, and then Sarah and I will continue with our recommendations afterwards. Thanks.
Great. Are you?
All right.
Okay, great.
So first of all, thank you to all of you to inviting me here today. This is a topic that I love. I don't get that often to talk about it that much because it's not something that many people are interested in. So I'm very happy to come here and have all of you captive for a little while to hear my spiel on FOIA. I run a website called FOIA Mapper, which is something of a search engine for public records. And for the most part, the piece that goes into it is FOIA logs. So I'm going to talk about some of the analysis I've done with FOIA logs, but I'm also going to talk about some of the other ways that I found FOIA logs just to be an incredibly helpful tool with freedom of information requests. So first, just a bit about my background. I've had a fairly twisty career path, but one constant along the way has been the use of the Freedom of Information Act. So I used to be a trader of insurance-linked derivatives, and that's when I first discovered FOIA, and I found it very useful, the information I could get in building catastrophe models, so models that would forecast damages from hurricanes and earthquakes and that sort of thing. After that, I founded a real estate due diligence business, which was also largely powered by information from FOIA. Since then, I've gone on to do data journalism and data visualization, and much of the data that I use for that comes from FOIA. And now, of course, I've founded FOIA Mapper. So this has given me somewhat of a fairly broad view on how FOIA is used. And the idea behind FOIA Mapper was really sort of what I learned, some of these tricks to sort of make requests a little bit easier. So this is something that all of you are no doubt familiar with. This is sort of this guessing game that happens with Freedom of Information requests, where the requester is not quite sure what to ask for and not quite sure what information the agency has or how to necessarily ask for it. And then internally, I found FOIA officers to be very helpful. But sometimes the problem is that I can't exactly phrase the question that I want to know very well. So even that sometimes is very difficult. And then of course, you have this issue of sort of this secondhand communication that goes through the FOIA officer. And if it is for something that's highly technical, I request a lot of information in database format. The pieces can also be lost in translation in that case. So what I found to be very helpful is the first thing I always do before making a request is I look to see if the agency has FOIA logs available. And I look through the FOIA logs. And best case scenario is that someone has already requested what I'm looking for, in which case that's the easiest request you'll ever make, which is just I'll have what you sent for that request. And those, I've had turned around in a day before. A more likely scenario is you don't find exactly what you're looking for, but you find the information you sort of need to figure out what to ask for. So, this is just an arbitrary example here of environmental hazard information, but maybe if you're looking for that kind of information, you look through the FOIA logs and you see mention of, say, a Superfund site or a brownfield site, and you say, okay, that's what I'm looking for. I wasn't familiar with that term, but once you know that term, that's sort of a keyword you can use to make the the description of what you're asking for much easier. So what I did with FOIA Mapper is I went out and collected FOIA logs from as many government agencies as I could at the federal level. I digitized them, which involved a lot of scanning paper in and optical character recognition and that sort of thing. I standardized them into a database and I made them searchable. So what you can do is you can search for a keyword and you can see any request that falls under that keyword. So you can see which agencies have it, how other people are requesting it, and that sort of thing. So, this is what I see as the big use case of FOIA logs. They're just such a helpful tool when it comes to making these requests. And, I think for the requester, clearly it saves a lot of time, but I think for the agency as well, for some of the issues that you folks were just discussing a moment ago, that these very broad kind of any and all requests, typically when I make those requests, it's because I don't really know what information is there or what to ask for. What I've also done with these requests that I've collected into this database as sort of a separate one-off project is a piece of analysis on who's using FOIA. So within the database that I have, there are about 229,000 requests from 85 federal agencies that include both the requester name and the name of the organization making the request. So what I did is I went through in a very long process, which I won't go into here, but basically categorized each of the names of the organizations to a type of organization using these categories. So this is not exactly a random sample, most likely, but it is a fairly large sample. There are about 300-ish government agencies in the way that I have them grouped. And yeah, these are the overall results. So consistent with what Margaret found in her great research, the news media only makes up a small percentage of the total FOIA requests, right? Even though that's kind of the most well-known part. Much bigger is the commercial business, also the individuals, and you have some other groups in there. The nonprofits and universities also make up a little slice. And this here is the breakdown by agency. So you can see for, looks like probably most of the agencies, the individuals, the red one, makes up the largest share. But it's some of the larger agencies at the top is where the commercial requesters come in. So looking at the individual categories, among the businesses, these are the 10 biggest requesters that I found. Now, what I found interesting here was You can see of the top 6, you can see the ones with the asterisk. 5 of them have that asterisk after them. What that means is that these guys are all doing something very similar. All of their requests are directed exclusively to the SEC, and they are all sort of very specialized research firms. And what you find here is that for the SEC, these guys over the past 10 years, these 5 companies combined have accounted for about 50%, I believe over 50% of all the requests to the SEC, which is a very large agency with a very large FOIA budget. And I believe over the past 10 years, the numbers were, the FOIA budget total was about 50 million. What I found interesting was that in terms of the FOIA fees collected by the SEC, I think they only added up to about 600,000, which means that these guys are not paying fees for the majority of their requests. And I can't speak to what's going on behind that, but I think that's a fairly interesting result. And something that you couldn't really see unless you had the FOIA logs. You can't see this with the information that agencies provide in their annual reports. And among the news media, it's mostly what you'd expect. The top 10 biggest requesters are all some of these all large, major mainstream news organizations. Next you have the political and nonprofit. So the political requests, what kind of jumped out at me here is it's just interesting to see that the Democrats are much bigger at these requests than the Republicans are. For the most part, these, by the way, are opposition research type requests. So things like, I request all communication from your agency with Marco Rubio as a way of kind of looking in and seeing if you could find something that, something wrongdoing or something that you can use against him. So this is, just a fairly interesting trend. And you'll also notice, too, that the Democratic Senatorial Campaign Committee, the largest, makes up 42 out of every 10,000 requests, which is larger than any of the news outlets, which I think is quite interesting, because I know news outlets, I know some in particular make lots and lots of requests. So it just kind of puts in perspective how big FOIA is for these political groups. Among nonprofits, I found this one interesting because it's really very mixed. There's not a clear pattern on top here, and I think some of these groups are represented here today, in fact. But you have a labor union, you have government accountability, you have animal rights on here. So yeah, it's fairly interesting that you have such a diverse group of nonprofits that are making use of FOIA. And then finally, you have the universities.
That's National Security Archive of George Washington.
Yes.
But we're technically news media, for the record.
Oh, okay.
Our fee status is news media.
I think you'd be number one in any case.
Oh, no, but it's interesting. I think we're put in, some people could say we're education.
So that concludes the research that I did with it. Just a few considerations on FOIA logs. Well, first of all, as I mentioned before, I think FOIA logs can be just an enormous time saver for both the requester and the agency. There was some discussion here before about the major information systems, which I think is also great, but sort of does sound a little intimidating and is not always that helpful if you don't already have some background on how to look at them. But I think something like, here's a list of what other people are asking for, is something that's actually like perhaps even more useful for someone new to FOIA, because it's kind of hard to know where to start. If you can see what other people are asking for, that's like a sort of really helpful to see. Another piece here, just very specifically, is the importance of the format. So I get the sense that a lot of agencies don't appreciate how much difference there is between receiving a FOIA log as an Excel spreadsheet versus receiving it as a paper document. Right? And in some cases, there's not much of a difference because some people, I suppose, just want to browse through the requests, in which case there's not much of a difference the format you receive it. But I think most people are looking for something specific, in which case the ability to search is extremely important. Or in my case, I'm doing research with these things, so the ability to put this into a database or to sort it and to filter it, that's also incredibly important. Of course, Excel, CSV is the best format. PDFs are tricky because there are two different types. There are structured PDFs, which are usually produced by the computer. So for example, if you convert a Word file into a PDF, or if you export a PDF from a FOIA management system, that will typically be a structured PDF, which you can search, you can highlight text, you can copy paste. So that's almost as good as a spreadsheet. Scanned PDF is much more common, I've found, where you'll have like this example here, where the FOIA log will be printed out because it needs to be redacted, and then it will be, excuse me, this is actually not this example. This one was not scanned back in. Normally, it would be scanned back in and sent to you as a PDF. And for my purposes, those are extremely hard to work with. And it requires some really complex tools that take a lot of manual work to be able to turn it into an electronic format that you can search through. This here is, this is one that I received. I requested in Excel format, and what I got back was this big box here of nearly 800 pages in printed out spreadsheets, which I fully appreciate why, because the redactions needed to be done, but there are certainly ways of doing it electronically, and I think even if the redacted columns there were removed entirely, I would still prefer to receive it in electronic format. So just one consideration there for the disclosure of FOIA logs. And then finally, one great thing about FOIA logs is they sort of never become outdated because the record systems tend to stick around for a long time. So seeing what someone requested, say, 5 years ago is going to be very helpful today. So frequent updates are great. It's helpful to see what people are requesting now versus a year ago. But the truth is that what really makes a difference is just having some FOIA logs up there to see what kind of information people are requesting from the university. And that's it. Any questions about the analysis? FOIA logs? Yes.
Sure. This is Michael Bekesha. Real quick, was there a big difference between the type of information that was on a FOIA log depending on the agency?
Oh, yeah, huge. Huge difference. Hard to make comments about that in general, but some of the immigration agencies, what you'll find is that's like entirely lawyers and individuals asking for very specific records about them.
I just mean like the categories of information. Like did some agencies have the name of the requester, the type of request, the type of documents,
yes,
how long it took to process, and
Yep.
other additional information? And
Yeah.
then did some have like less specific information?
Yes, absolutely, yeah. The information fields that are included. There's a very big range. The ones that were common are usually the date, which can vary between agencies, what date they use, whether it's the date received, the date it was perfected, the date that it was responded to. You will have some information about the request usually. Sometimes it's just kind of one or two words saying what the request is about, some sort of like category. Other times it's the full text of the request. And then there's a very long list of fields that are kind of perhaps not that common with most agencies, but you'll see occasionally. So things about the type of requester, are they a journalist, are they a commercial business, the amount of fees they paid, the exemption that was cited if the request was denied, that sort of thing. So yeah, it's a very big range.
Do any of them have the name of the person processing the FOIA request?
Yeah, some of them do. Some of them do. And I would find that helpful to see, I think, just to see if there are patterns. I would be interested to see if there are patterns by processor. Yeah.
Thank you.
David Pritzker. Two questions about the situation you described where you discover through the FOIA logs that someone has already asked for exactly what you want.
Sure.
To what extent are agencies required to keep, as a separate agency record, the results of the search for that request?
As far as I know of, there is no requirement to do that. But I believe there is, at the very least, I don't know. All agencies I know of keep a set of notes for each FOIA request. And most that I know of keep the results. I have come across sometimes when I've made a request like that where I've said, you know, I would like the records that you sent in response to request XYZ. And they've said that, oh, they need to prepare that again. But I've never come across a case where I asked for the request that someone else made, and then there was confusion afterward about what was I wanted or any kind of like difficulty. It's always been a very smooth request.
And the other thing I wanted to ask is, suppose they've already searched for something that you want. As a matter of transactional time, how much of the 20 days does it typically take for the agency to respond to your identical request? And is there much variation among the agencies?
There is variation. I think I mentioned before, the fastest I've gotten one back was 24 hours. So I've had them back like immediately afterward. And you know, in most cases, yeah, I'd say I definitely get them back within the 20-day statutory period. You know, sometimes it takes a little longer than that, but you know, compared to other types of requests I've made, like those are the smoothest ones that you can make. So there is variation, but it never goes, you know, 6 months or a year like other requests can.
Okay, anyone on the phone have any questions? Okay. Thank you so much for coming and sharing that great data. I think that was really fascinating.
Thank you very much.
So I know we're running a little behind schedule. I'm going to ask Margaret and Sarah to go through their proposals quickly.
So Margaret is going to go through them quickly. I unfortunately have to go for an appointment out in Rockville at my office. So I'm going to say I'll be dumping this now on Margaret to handle entirely, but thank you all.
I would want to say thanks to Sarah for all her work on the committee before she runs out the door, and also thanks so much to Max for making the trip down from New York to share some of his work about FOIA logs. And I want to briefly summarize. We circulated 3 documents, and I want to. I'm going to be very brief about summarizing them because I think they were, you know, largely self-explanatory. But I'm going to start actually with the one about FOIA logs, which ties in with Max's presentation. So the Proactive Disclosure Subcommittee has actually conducted over the past year, we've conducted a number of kind of interviews with agency personnel. We've also kind of sifted through various other types of recommendations that have been made, and we eventually coalesced around what will probably end up being 4 and are currently only 3 topics that we are separately addressing. So the first one is about FOIA logs, and this recommendation is actually for agencies to publish on a regular basis their FOIA logs with a standardized set of fields and information. So one of the things that Max alluded to that I found in my own research, and I think that has been true for many other people who have attempted to use the logs, is that it's very difficult to study what's going on across the federal government when data about transparency itself is not kept in a uniform fashion. And so this was an attempt to be just incredibly specific about what that uniform fashion would ideally look like, and an attempt to kind of give some content to why these various fields would be useful to the public, to researchers, to news media, and generally for our understanding of FOIA. And the background section describes a bit about the various ways that the logs can be useful. Max has done a great job illustrating that. But I think, Max's presentation highlights how it might be useful also for agencies in terms of saving time, because requesters might be able to use the logs for efficiency. I think also as a recommendation that goes to kind of more transparency about about our transparency laws themselves, that it has sort of an overarching theme, and might give us more information about all of the other areas that we're looking to improve on FOIA in terms of response times, in terms of what kinds of requests tend to be easier or harder for the agency to fulfill. This data will give us perhaps more information, and is data that agencies, frankly, are usually already keeping because they're already tracking their requests. And so finding a way to do that uniformly so that we could understand what's happening across the government was our driving concern. I'm going to highlight one thing that there was discussion about on the subcommittee that we have not resolved, which is about whether the names of the individuals' names of the requesters should be part of the recommendation. As originally drafted, it would have been the name of the requester so long as it's not a first-party request. So someone, Margaret Quokka requesting all information about Margaret Quokka. So long as it was not that, which the Department of Justice has issued guidance that suggests that may have some additional privacy concerns, but also probably has less value, right, in terms of understanding what's happening in requesters. And so the original drafting would have included the names of all third-party requesters, so anybody else making a request. There was some discussion about whether an individual making a request, even if it's not about themselves, whether their name should be included in a published version of the log. I can say personally, my own opinion, not the opinion of the subcommittee, was that it should, that the Department of Justice guidance is clear that there's no real privacy interest in the fact of having made a request, and I make individual requests all the time and feel no privacy interest in that, but I understand there's disagreement on that question. So I flagged that for the committee to consider. And other than that, I'll just say that the listed actual proposal is in section 3, starting on page 5. The second set of recommendations concern an attempt to make generalized guidance that could apply to all agencies about how to prioritize records for proactive disclosure. So what kinds of criteria agencies should be considering. And the background section discusses various legal requirements for proactive disclosure, also talks about current agency practices, things that agencies tend to disclose, and from that tries to flesh out kind of a way to categorize what seems to be most important and how to memorialize that in a set of criteria. So it focuses on agency actions taken pursuant to their statutory duties, original government collected or maintained data that aids the public's understanding about the world, which is like generally kind of scientific data or other data that agencies are collecting that help the public. And then the third was categories of records that are frequently requested by the public, even beyond the mandate in FOIA that requires a particular record requested 3 or more times to be published. This would ask agencies to look at categories of records that are frequently requested for possible prioritization for proactive disclosure. And so the actual recommendation, again, starts in part 3 on page 4 and tries to very specifically lay out the various criteria and considerations that agencies should use. And then our third set of recommendations were about actual instead of criteria for deciding what to disclose, actual categories of records that should be prioritized. And I will say the methodology for coming up with this proposal, I don't know if Tom Sussman is on the phone yet, but this was his brainchild, so I want to give him credit, but was to say, look, there's been, obviously organizations, nonprofits who have come up with lists of things that agencies should disclose. We culled from those. We also put out a general call for proposals to come in. It was posted on OJIS's blog, circulated on various listservs, asking for ideas for records that should be targeted for proactive disclosure. Amy, all credit due there, then came up with a system for the subcommittee to go through and rank each item that was proposed for importance and the ease of posting. So whether this would be something that agencies could relatively easily undertake, or whether it would be relatively difficult because of potential redactions or concerns about exemption or other logistics. After we created that basic rank ordering, we had a set of 3 lengthy calls where we went through each item in detail and tried to form consensus around whether we should include it, whether it was kind of low-hanging fruit for inclusion on this list. And this list then now is the result of that process. And there's a couple of notes in here where we've said, we're reiterating something that may already be required or suggested by the law, and we just want to reiterate its importance. And then at the end of this list, so all of subsection 2 are the things that our subcommittee coalesced around. Subsection 3 is a list of 3 additional items that we were unable to reach resolution on and for which we wanted this committee's input. That starts on the last page of this recommendation. And so with that summary, which I apologize wasn't as brief as I wanted it to be.
No, that was great, Margaret. Thank you. Well, let me just open up, obviously, to the whole committee to comment. If you want to start with the 3rd proposal, that's fine. If you want to go in order, that's great, too. Nate.
I just wanted to note that an additional thing that was not ready for this time that we're still working on is we spent a lot of time on 508 compliance, and the subcommittee is about to circulate recommendations that we hope to get out of the subcommittee quickly to you guys within a week. So even though it's not in front of you right now, the subcommittee is debating our recommendations on 508 compliance as well. So there's one more thing to keep your eye out for.
Thanks, Nate, and I apologize. I started by saying we will have 4 recommendations and have 3, and then failed to identify the one that we're still working on. So thank you very much. Yes, that's exactly right. We've actually spent quite a bit of time talking about 508 compliance as an area within our purview, and are hoping to make recommendations shortly about that as well, that we have currently in draft form, but not yet ready for this committee.
Okay. Other questions or comments? Sean?
Yeah, I was just going to point out that on the 3rd document that was introduced about the priorities, the list of priorities, the items that are listed there, it's about 11 items, I think. They're not categorized, but they really do stay in the order of the early ones on the list were seen as important and easy, and as you move along, they get more difficult as you get towards the bottom of the list. So. And it was a much longer list that we went through, and some got tossed off simply because of the difficulty in posting them and the sort of lack of importance. So.
Thank you. I want to invite folks on the phone. Anyone have any comments or questions? Logan, you're not on the phone. You're here.
Here, I just wanted to offer a few comments on some of the categories of records, just things for consideration. On unclassified reports that agencies provide to Congress, I would consider adding correspondence as well. A lot of letters are traded. I don't know if you considered that. I would recommend that. On the employees and directories and contact information, I would point you to OPM's data release policy. A lot of agencies are going to have, law enforcement and other names that are very sensitive and can't be released, and there's lots of, the OPM data release policy is a good place to look, and maybe it's that your recommendation is consistent with that policy, which is a government-wide policy. Just kind of running down the list. Agency visitor logs, my thought was if it was for official business, that's great. Some people work in facilities. I work in a facility. If your child or spouse needs to come while you drop something off, you've got to log them in and give their social security number. You guys probably want to exclude that to the extent you consider that the meeting is, the visitor log is for official business and not like a tour or something like that. And then OLC opinions, Melanie may have her own thoughts on this, but I think if you look at the OLC reporter over the years since people started requesting these, it's gone skinnier and skinnier and skinnier because OLC has written less and less and less opinions because they're more subject to FOIA, and I think that ultimately harms agencies. So my vote would be against including that on the list.
Okay, great.
If I can just briefly on one thing, I wanted to, and thank you for all of those points, which we'll come back and discuss certainly in the subcommittee. One thing on correspondence with Congress, we actually had a lengthy discussion about this. It was originally on our list and decided on excluding it because so much correspondence is, for example, constituent services. And it seemed to us that it would be difficult for us to kind of figure out how to craft that such that we didn't end up overburdening agencies by having correspondence where they have to make privacy reductions for constituent services and also where no one really, cares. And so we eventually decided, because of difficulty and potentially large volumes of records that don't have a great public interest, that we would exclude it from the list for that reason. But certainly if there were a way of phrasing that you could think of that you wanted to suggest to our committee, we would be open to revisiting.
Maybe committee correspondence and not with individual senators or members of Congress doing constituent work. Would be a possibility.
Yeah, that's a good idea. We did also, the visitor logs ended up on that second list because of exactly the concern that you just raised. Also concerns that were raised were, agencies that have lots and lots of locations. What are we talking about when we say, even large agencies, even their headquarters has lots of buildings, et cetera. So, that was why. The difficulty of that and the potential, concerns around non-official business were exactly the problems we identified.
This is Ginger. I wanted to echo Logan's concerns on the visitor log issue, and also talk about the employee directories and contact information. I don't know what the current policy is on this. I haven't taken a look at the policy that he was talking about, but I think that's definitely a useful place to start. I know at Labor, if we're calling out from the agency, our phone number doesn't show up. Like my individual phone number wouldn't show up for you. It would just show up as like 9999 as the last 4 digits. And there's a good reason for that. Because if you want employees to be able to do their work, you don't want them to be having to take constant calls from random members of the public. We have OSHA inspectors who are law enforcement inspectors. We don't include, when we release documents, we would redact those inspectors' names and contact information and even their inspector IDs most of the time because we want to protect those people from retaliation. And even some of our non-law enforcement agencies, there are very, very real reasons that we wouldn't want email addresses and contact information released to the public. So I think from a privacy standpoint, there are definitely more questions that need to be asked before that kind of information is released.
Yeah, I just want to make a comment, and I want to echo what Ginger's saying. Having been at the FBI for almost 15 years, where, of course, we protected all the time consistently employees' names, whether they were agent or support, coming over to the National Archives, it's sort of the flip side. Everything is public. All the employees' names are listed on the website, and you go and you can call anyone you want. So it's just very interesting, two ends of the spectrum that I've had the opportunity to observe. So I see both sides.
Also, Ginger, again, logistically, I think that's going to be a difficult requirement because agencies are losing people and gaining people every day. For a large agency like, for instance, the Department of Labor or some of the other even larger agencies, to keep that database constantly updated might be problematic.
This is Michael Bekesha. I think one thing that you could see is the State Department has a public list of senior level employees and their phone numbers, not email addresses. And that's updated, I think, every 6 months or so. And so maybe we're not looking or talking about, or people even care about every employee of an agency, but of some rank, of some level, head of a bureau, for example, in the State Department.
Capstone officials.
Capstone officials may be a good way to limit it. And maybe, avoiding email address, but phone number, people can easily ignore a call and have it go to voicemail, and that's almost less intrusive than email these days, I think, for people. So, there's probably some middle ground between no disclosure and some disclosure, but could be resolved.
Great. Any other? David?
Are all of these subcommittee documents that we've been talking about today posted on the website with a request for public comment?
Yes.
It's already there?
Yes.
Good.
We can thank Amy for that again. All right.
Let me just flag for the
sure.
committee, just because the other items the only other item that we haven't yet touched on about full committee consideration was congressional budget justifications. I want to raise that. Also, if you look at item J, this is about we considered contracts. And the suggestion, there were various iterations of the suggestion. So one was, well, every agency, just like the top 10 contracts they have by value. Or then for a while we were like, well, maybe we should have a cutoff at a dollar value, or maybe both, or one or the other. And then there was what dollar value. So I wanted to flag that for the committee in case anyone has any input on that they'd like to offer. And then finally, just because I flagged it once before, but just because it was one of the things that we expressly wanted the full committee's input on names on FOIA logs. And so I'll leave those last things in case anyone else has anything else to say about that before the subcommittee goes back and tries to formulate a final decision.
So this is Logan. Did you guys check what was publicly available for government contracts and see what was missing? Not through FOIA, but on Fed BizOps or some of the other contracting government websites where you can see every dollar amount of every contract and who won it and the bids.
Yeah, I'm referring this to Sean.
This is Ginger. I guess this is a question tied to that. Is what you're looking for really statements of work or things associated with contracts, or just the contract itself?
Yeah, well, I mean, I think we're looking for, I think ideally you're looking at the contract, but even a statement of work from the contract from some of these are thousands of pages. But the idea that right now on Fed BizOps or on USA Spending, you can get the name of a contractor and the amount that they got. And generally the description, you're lucky if it's an actual sentence with nouns and verbs. Usually it's a title. And it's fixed wing aircraft, and you don't know how many or what kind of aircraft it was, or construction, and that's it. And so the idea was, if you're going to be spending $100 million or something like that, that we should be able to get a little bit better idea of what it's actually being spent on.
I think that makes sense. My only other suggestion would be if there's a way to kind of narrowly craft it, because a lot of the times, right, folks are taking out sensitive business information, which is not the government's. The government, doesn't generally care about it. It's the business entities who won the contract. So if there's a way to scope it around that, I think it makes sense.
And I will say that some agencies, just from having experience in this area, NASA, Department of Energy, with some of these really huge either equipment contracts or laboratory contracts, they're up. They're not centralized always in one place, and it can be difficult to find, but generally some of those agencies are already putting out some of these contracts in their kind of complete form.
But in response to FOIA requests?
At this point, some of them are proactive, and it may be because they know there's going to be requests. So it's.
I know DoD has post proactively a lot of contracts.
Yeah, I don't know if it's all of the big ones, but yeah.
Great, thank you. Any other questions? All right, anyone on the phone? You guys still there? All right. Margaret, I think you're good?
Yep.
All right, thank you for everyone's feedback. I'm now going to give an opportunity for members of the public to come up and ask any questions of the committee. We'll take questions for a few minutes. I think we're all kind of tired, so please hang in there for the stretch. When you do come up to the mic, please state your name and your affiliation, and that way we have a clean record.
Good morning.
Good afternoon.
My name is Alex Howard. I'm the Deputy Director of the Sunlight Foundation. Thanks to everyone who spoke today. Again, really fascinating discussion of the issues. Thank you for all of your work and your subcommittees. I hope that your recommendations receive the serious consideration that they deserve and actually are taken up and carried out, as has not always been true in the past. Two things to bring up today. One is related to a recent issue that I don't think has been raised today regarding ICE's FOIA reading room. As you may know, the agency mistakenly disclosed the private information of a number of people who contacted the tip line that was set up by this administration regarding crimes by immigrants. The agency put the private information of some of the people that contacted them on the internet on a server, as we understand it, unrelated to its FOIA reading room. This breach was disclosed not publicly, but reported on by Splinter News. ICE then took down its reading room. We understand that to be statutorily mandated reading room without notice or explanation. Simply took it down. They refused to answer media questions about it, to release any statement. It simply went away. This morning, I checked, it's back with no statement or information regarding what happened. There was only a statement posted to the page before. Someday it'll be back. Now, it seems clear what occurred. The agency made a real error in doing what we think is actually a pretty bad idea to begin with, targeting certain people in our country for crime statistic collection versus the entirety of the country seems to us to be weaponizing disclosure in a way that is certain to undermine trust in government. Now that they've actually gone ahead and posted this information, trust it will be undermined. You're going to call a tip line that publishes your personal data? In the meantime, we have an agency that refused to speak to the public, to return the inquiries of a nonprofit transparency watchdog, or to account at all for why it took down its reading room. This seems to me something that this committee and the people on it should be talking about. We still don't know if the DOJ can offer more than guidance, as opposed to nudging them to remind them that this is something they're supposed to keep up. It seems to be something that perhaps an ombudsman would be relevant to. But our understanding is this agency is the target of some of the greatest volume of requests about some of the most important, marginalized, powerless populations in our nation. And it is unaccountable to us or the public with respect to the files it was making available for inspection. That's unacceptable, and I hope that you all speak up about it, look into it, and get some kind of statement from the agency and encourage them to talk publicly about why they're changing these things and to be accountable for making mistakes. That's one thing. The second is a simple question. The Department of Justice, the end of the last administration, asked the nation, asked watchdogs, asked journalists for feedback on a release-to-one, release-to-all policy for the Freedom of Information Act, something that Sunlight happily gave feedback to. I've come here and asked repeatedly about the status of that policy. There's no statement. There's no information. What's going on here? Was that a facade of participation? Is the department and the government going to be transparent about what's going on with this policy, or should we simply drop it and go to Congress to mandate what you all won't do voluntarily? Thank you.
I'll speak to ICE. I agree. I think that I've said for a while that I think that the advisory committee does have a role of speaking out about FOIA. I know that there's an aversion in the government for one agency to tell another agency what to do. So maybe us outside of the government should do it. I remember last committee there was a report that an agency, AID, said that, well, we can think that our very slow FOIA process means that this embarrassing incident about creating a fake Twitter in Cuba won't get out, and I spoke out there. Clearly, there may be reasons for taking off down a government website, including privacy information, but it certainly was a missed opportunity. I think the public would have been much more understanding if ICE had communicated. We talked for about an hour today about communication with requesters, about what happened, why it happened, and what was going to be done to fix the problem. So I'll say that if this happens again, and it probably will, agencies need to tell the public that the website will be back, and we made a mistake, and we're trying to fix it. So that's what I can say.
Well, and this is Sean. I think you draw a good connection there. I mean, we talked about communications with individual requesters about their requests, but I think some of what we're talking about, the public outreach, public education we talked about, I think we could strengthen that to talk specifically about when either tools are down and we're asking now for probably looking to ask for logs, FOIA logs, and so we should have something in there about when these information is not available or tools aren't available, that there's a requirement or there's a recommendation that they communicate why and when they'll be returned.
Yep. Okay. Anyone else have any comments? in response to Alex's?
I guess I'll just say that maybe I missed it, but I'm also interested in this data of release to one, release to all, eventually.
We don't have any update. That's the reason you're not hearing anything. There is no update. It's still under review.
So I'll say my constituents that I'm representing have a thirst for it.
Yeah.
We were excited and still are excited and hope it didn't just go poof, but.
My office continues to support the proactive disclosures, as you know, we have for years. And with the requirement now that records that are requested 3 times, that's now a legal requirement. So, I mean, there are a number of ways, and we also know that there are multiple agencies already posting all their FOIA releases, so we do have a lot of progress in the area of proactive disclosures of FOIA releases. So we continue to support it, obviously, but I just don't have anything to update you on specifically on our policy.
Okay, there is thirst for it.
I mean, this is Michael
No, and I
Bakesh.
appreciate that.
I mean, just one response to that, and as Alex pointed at the end, I mean, if the FOIA community thinks that's important, it needs to be done, then they should go to Congress. And people should start talking to the congressmen and trying to get that as part of the FOIA law, as difficult as it may be to get FOIA reform a year after other not-so-great FOIA reform. May be difficult, but why not? I mean, why wait for the agency to go through their process if it's so important? Bring it to Congress's attention.
Just to be clear, if this agency does not actually do anything with the public feedback that they're being given on this policy, why should the nonprofit community, trade groups, journalists, or indeed any of their stakeholders who are represented by some people on stage trust the next stage of give us feedback for some purpose as being meaningful? Being non-responsive, when you encourage the public to participate, is an excellent way to erode trust in the value of that participation. I hesitate to draw a parallel, but it is a pretty clear analog to what's happening at We the People, petitions.whitehouse.gov, where the administration is taking the feedback of the public, petitioning government, and responding nary at all. At some point, it leads to us thinking you are taking in feedback but not doing anything meaningful with it. And I would encourage you all to come down on this one side or the other and be done with the review, or to simply withdraw it. Because bringing it out like this leads me to believe that we can't tell people that this kind of informal rulemaking has merit. Instead, it has to go through an NPRM, or it needs to go through the legislative process. I don't want to do that, but if the DOJ is not responsive and agencies don't even respond to inquiries about the status of these things on the record, what choice do we have? Sorry to be upset here, but it's October.
Okay, we understand, and thank you, Alex. We'll take all of that under advisement. I want to wrap it up because I know everyone is eager to get to lunch. I apologize that we went over a little bit, but that makes up for the last couple times when I wrapped up early, so you owed me. I want to thank everyone for all your work. We again invite everyone to visit our website and social media for more information about activities and input that you can give, especially with regard to the subcommittee proposals we've talked about today. I want to remind everyone our next meeting is Tuesday, not Thursday, January 16th, 2017, right here in the McGowan Theater. We couldn't get Thursday, so sorry about that. 10 a.m. So we look forward to lots of good work continuing through the holidays. I know it's going to be a tough time, but hopefully everyone will keep up all the great work. And unless there are any questions or concerns, going once, going twice. Folks on the phone, any other thoughts or questions?
Not from me.
Okay, great.
So thanks.
Okay, then I believe we stand adjourned. Thank you.
Good job, Mark.